Good morning, everybody. Happy Super Friday. Welcome to TCF Live. My name is Dan Soul. I will guide you on this 3-hour journey through Courtlandia, starting today with Judge Anzalone.
This is in the matter of Mr. Avila. If you want to start your audio and video, thank you. This is file number 2025-22279FH. In the matter of the people of the state of Michigan versus Tomas Angel Avila. I have Isaac Sneed appearing on behalf of the press. I know we're picking up backup noise. I can't do anything about it. I have Isaac Sneed appearing on behalf of Mr. Avila, and I have Dylan Rockett appearing on behalf of Mr. Avila today. So I do have a letter from the prosecutor in this matter, or from Darren Coast in this matter. Mr. Avila had pled under a delayed sentence, and Mr. Coast stated that Mr. Avila had paid his fines, costs, and supervision fees in full as directed. He has remained out of trouble. Mr. Coast did verify that by CCH, and per the plea agreement, Mr. Sneed, are the people going? How would you like to proceed?
If the defender's office would like to prepare a stipulation to withdraw the plea and dismiss the case, we'll get that signed and filed with the court.
All right, so Mr. Avila, thank you very much for being in compliance and taking care of this matter. Mr. Rockett will be preparing a stip in order to set aside your plea and dismiss the case. And you are all set. Any questions, Mr. Avila?
No, thank you. I appreciate it.
All right, thank you, Mr. Avila.
Thank you, Judge.
All right.
Thanks, Judge.
Good job, Mr. Rockett. And let's see. All right. Then, Mr. Rockett, you have Jessica Stahl.
Yes.
Are you need a breakout room?
No, I spoke already.
All right. This is the misdemeanor, Miss Teskey. All right, this, Miss Stahl, if you can start your audio and video, please.
Okay, sorry.
It's okay. I'm gonna bring Mr. Wade back in.
Let's pause for just a second. Barbara, thank you for the $10. Update, my mama's coming home either today or tomorrow. I just wanted to pause because that's good news. That's very good. Thank you, Barbara, for sharing that, and thank you for the $10. Let's get back to it.
All right, this is file number 2026-22575FH in the matter of the people of the state of Michigan versus Jessica Elizabeth Stahl. I have Dylan Rockett appearing on behalf of Ms. Stahl. Ms. Stahl is present via Zoom. Mr. Rockett, you did receive a copy of the misdemeanor sentencing recommendation. Is that correct?
Correct, Your Honor.
All right, Ms. Stahl, have you had an opportunity to review the pre-sentence report?
I have.
Have you had an opportunity to speak with Mr. Rockett?
I have.
Are you satisfied with him as your attorney and the advice that he has given you?
Yes, I am.
Mr. Rockett, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
The only thing I can say about it is all of the unknowns that are in the pre-sentence report. I guess it is probation and Ms. Stahl were kind of playing with a little bit of phone tag. So when probation reached out to her, there was some miscommunication there. She attempted to reach out to probation, and the two parties were never able to fully actually speak on the pre-sentence investigation.
Speak up a little bit. They were never able
to fully speak about the pre-sentence investigation.
Okay. All right. Now the probation terms recommended were counseling as required, no contact with the Brianna McFadden, signed any and all releases, and no assaultive behavior, and there was no objection to any of those, right?
Correct.
Okay. All right. So, Mr. Recca, is there anything you'd like to say on behalf of Ms. Stahl?
Yes, I would, Your Honor. Just as stated, there was a little bit of phone tag going back and forth. Ms. Stahl did not intentionally fail to interact with probation and fill out the pre-sentence investigation. During the time of attempting to coordinate with the pre-sentence investigation, Ms. Stahl's mother did unfortunately pass away due to some underlying illnesses. She was kind of focused on doing that, dealing with that, going back and forth between her brother's home, caring for him as he has recently had some surgery, dealing with the unfortunate and untimely death of her mother, caring for her stepfather during his own grief during the events. So again, she wasn't intentionally trying not to interact with probation, which I think speaks to the probation officer's comments of not having a lot of confidence in success on probation. I think that had the circumstances been different, she would have fully engaged with the pre-sentence investigation, and she's looking forward to engaging fully and accurately with probation going forward. As far as probation is concerned, Ms. Stahl does have a home up north, a few hours away up north. She's going between that and a home here, taking care of her brother and her stepfather. So I don't know if probation can coordinate that between.
She'll just have to be here for her check-ins.
Okay. So other than that, it was a difficult time for her, and she's taking responsibility for what happened. Definitely wants to go forward in a more positive light.
Okay. All right, Ms. Stahl, is there anything you'd like to say on your own behalf?
No, thank you.
All right. And you're not with this Dustin anymore, correct?
No.
Good. All right. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication of the law, and the protection of society. Ma'am, are you employed?
I was taking care of my mother and my stepfather through Wellwise, their insurance company. But because of this criminal situation, I wasn't approved. So my brother just pays me accordingly. He actually goes through their insurance Wellwise and gets paid, but he just pays me accordingly.
Okay. All right. Thank you. All right. So it's sentence of the court. You'll be placed on probation for a period of 6 months. During that term of probation, you will obey and comply with all the articles of your probation. You will submit to any counseling or evaluations as required. You will report as often as required, not communicate or associate at all with this Brianna McFannon. I think you should have been mad at your boyfriend because he was there too. And then no assaultive behavior of any nature, sign any releases as required by the probation department. There's a $200 fine, $50 in state costs, a $75 crime victim rights fee, $300 in court costs. So you'll have 6 months to pay that off. So you're gonna have to make a monthly payment on that, all right?
Okay.
Now, I'm not going to ask you to put your address on the record, but I want to ask, is your house number still 2329?
No.
Okay. So when you report to the probation department, you need to update your address.
Okay.
And Mr. Rockett, do you have our address up north?
I don't believe so, but I can get it.
Okay, so we'll have him get your address from you because we're gonna mail to you your notice of right to appellate review. If you wish to appeal the sentence, you would fill out the information on the form and sign it and send it back to us within 42 days. It will come in an envelope, and then in that envelope will be 3 copies of your notice of right to appellate review. One will be marked for you to initial and date, just to acknowledge you received the paperwork. There'll also be a self-addressed stamped envelope in the envelope. And then you're gonna put the one you initialed and dated in that envelope and mail it back to us so we know that you received your paperwork, all right?
Okay.
Next Thursday, between 8 and 10, right, Joanne, Thursday, is that what we tell people? I never remember for district court. But next Thursday, not this week, obviously, but next Thursday, I need you to report to the district court probation department between 8 and 10 a.m. to discuss your probation terms, okay?
Okay.
If you don't show up, then it could be a violation of probation. Got it?
I do. I will be there.
All right. You're all set, ma'am. Thank you.
Thank you.
Alrighty, good morning once again, everybody. It is TCF Live on a Super Friday. My name is Dan. It is good to have you here. Why is it a Super Friday? Because we don't do regular Fridays around here, because we're special. All right, let's stay in Michigan. Let's go to Kent County, the Grand Rapids area. This is Judge Rossi.
People of the state of Michigan versus Ahmad Davis, case number 25-10742-FH. This hearing is being recorded on Zoom and live streamed on YouTube.
And this matter is before the court this morning on the defendant's motion for amended bond. Counsel, will you place your appearances on the record?
Tiffany Burks on behalf of the people.
Lynn Craigsman on behalf of Mr. Davis.
All right. And Ms. Kriegsman, this is your motion. And I did note I did receive a bond report from court services indicating that they are not in favor of modified bond because, to quote them, he's got the pending. He's on height of probation on a weapons charge. 2025, he picks up this one, which is also a weapons charge, loaded firearm in downtown Grand Rapids in a high traffic area, with a round in the chamber. So, what are your thoughts? I mean, it seems like community safety is what they're driving at here, although I think he's got an FTA in there somewhere as well on his record. What are your thoughts on that?
I don't know if Ms. Burke has anything to input at this point, but beyond what was written in the written motion, I mean, it's a $50,000 10% bond that's obviously been unaffordable for him as he's been in custody since November. While I recognize certainly that a weapons charge is a potential risk to the public, I don't believe he's ever been convicted of anything or even alleged to have used that weapon in anything assaultive. And as I'm sure the court is very aware, bonds are constitutionally required to be affordable. He's taking responsibility, has already entered a guilty plea in this case. So we would just ask for those things to be considered beyond what's already in the written motion.
All right, Ms. Burks.
Thank you, Your Honor. And I believe the court is accurate in this, that the defendant was on or is on height of probation for a weapons count, carrying a concealed weapon, and then also on height of probation for discharge of a firearm in or at a building. And I know that I've heard this court say before that the worst thing that you can do while you're on probation or bond is pick up another weapons offense, especially a gun offense. Here, the allegation is that there wasn't an actual assault and that the suspect or the defendant in this case had a handgun on his person. So I mean, to say that he hasn't shot at anybody yet, well, he has discharged a weapon at a building at some point in time back in 2025, which was just last year. So I do believe that he poses a risk to the community, and I would ask the court to deny the motion.
All right, and that's my sense as well, is that the community risk is simply too high here. He has racked up, 3 firearms charges in relatively short order here, and just simply would be a risk to the community if released. And of course, given the fact of his probation for a firearms charge and the fact that he's committed another firearms violation, a length of time in jail is entirely possible. And of course, I would anticipate gaining credit for that while in jail. So I'll keep bond as currently set.
Thank you, Your Honor.
Thank you.
Next is the people of the state of Michigan versus Jordan Tunison, case number 26-03372-FC. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter also is before the court today on a bond motion. I would invite counsel to place your appearances on the record.
Tiffany Burks on behalf of the people.
Frank Gears on behalf of Mr. Tunison.
All right. And Mr. Gears, this is your motion. I did receive a report from court services indicating that they are not necessarily opposed to a PR bond with release directly to the guardian in this matter. And that's what you're proposing. And that's for evaluation or admission. What's the situation that he's looking at if he does get discharged to the guardian? Is he already admitted to mental health treatment?
I believe in Miss Del Castillo, I see is present on Zoom. That's the legal guardian and his aunt. I believe it'd be a long-term placement. And so it wouldn't be just for evaluation. I believe that there is a space available. So that could happen relatively soon if the court would allow for that to happen. I think it's a specialized place. I think it would be really in his best interest to be there outside of jail at this time.
All right. And Ms. Del Castillo, can you hear me? You'll have to unmute, ma'am.
Yes, I can hear you.
And what Muskegon facility do you have in mind to place Mr. Tunison in?
Well, I have changed it to a place in Byron Center, actually, because the one in Muskegon that was just like it was not one to go into, where they keep them.
Yeah, not a residential facility.
Yeah, and they said that.
Which one in Byron Center are you thinking of?
Hold on. Sorry, I'm not real prepared right now. I didn't know this was going to go down. No one told me. So I thought it was a bond hearing for. Okay. What's the name of that place? Oh, South Ridge Behavioral Hospital in Byron Center.
Okay, and that's an inpatient facility where he could actually reside there.
Yes, that's the only thing they do. So
okay, and there is a space, and that's your intention, is to be able to transport him there, and he's already they've already indicated they've got room for him.
Yes.
Yeah, and I know those are sometimes a little hard. Excuse me, boy. Yeah, smoke particles must be getting to me here. Okay, well, I am grateful that you're willing to do that. Yeah, so I will grant, well, Ms. Burks, let me hear from you first on the matter.
Your Honor, people don't object.
All right. Well, and then in this case, I will reduce the bond. It's currently set at $20,000 cash or surety. I'll simply amend that to $20,000 in a personal recognizance bond with the added term that Mr. Treson be released directly to Ms. Del Castillo and that Ms. Del Castillo obtain the treatment for him at the Behavioral Health Hospital in Byron Center, Michigan, as additional terms of bond. And if those can't be fulfilled, then Mr. Treson will have to remain lodged in the Kent.
One thing, Your Honor, if I may add, I believe we had to have this kind of a two motions here because there's two separate cases. I believe we were here a couple weeks ago on a bond motion on his prior case, and I believe the court set that at a $2,500 bond. Would the court amend that as well to a PR bond with the same conditions?
What's the prior case? What's the charge?
That was R&O's causing injury.
Yes, I'll amend that one to $2,500 PR as well.
Okay, thank you.
Thank you.
Brent, do you happen?
Alrighty, friends. Good morning once again. TCF Live. Let's go to Judge Elmore. He's in Missaukee County this morning.
Record now today for the 28th Circuit Court here in Missaukee County. And we begin today by taking up the case of People of the State of Michigan versus Andrew Donald Young. This is case number 26-3672FH. By the way, did anybody catch that? 36, you times it by 2, you get the other 72. Never mind. All right, folks. Appearances from counsel, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor from Missaukee County.
Okay.
Robert Hartzell from Mr. Young, Your Honor. I know he hasn't requested an attorney on this yet, but if we could file an immediate appearance, I do believe we'll reach the resolution.
No problem. We'll get right to that. But Mr. Young, who's currently in pretrial custody or custody based upon this alleged probation violation warrant, is here seated next to Mr. Hartel. Also here this morning is Mr. Luke Blazak. He's the agent from the Michigan Department of Corrections, serving as the probation officer on this file. We are here today for an arraignment on a request and warrant for a probation violation. Mr. Young, I need to tell you what those allegations are, what your rights are, and your possible consequences. Then we'll see how you wish to respond. There are 3 counts. Each count alleges that you violated condition 4.16 of your terms and conditions of probation. Each of them involve an alleged act on July 8th of 2026. Each of them allege that you violated a condition that requires that you are not to have any written, verbal, electronic, or physical contact with Katie Hoisington. Hopefully I spelled that correctly. Hoisington. Count 1 is that you allegedly talked to her in person on or about, or no, you called her and talked to her on that date at about 2:05 p.m. And then later, a couple hours after that, you then called her again at approximately 4:37 p.m. And then again, for count 3, called her again at about 5:32 p.m. You have the right to challenge these 3 allegations at a contested hearing. At that hearing, the prosecutor would have the burden of proof by a preponderance of the evidence. You could question and cross-examine any witnesses presented against you, review the evidence presented against you, as well as present witnesses' evidence or testimony if you chose. You also have the right to be represented by an attorney at that hearing and all subsequent proceedings. If you're found to be in violation of your probation, you would be resentenced on your original offenses for which you were convicted. Those included assault, resist, obstruct a police officer, which is a felony punishable by up to 2 years and or up to $2,000, as well as operating while intoxicated or impaired as a second, which is a misdemeanor punishable by up to 1 year and or up to $1,000. These are the first set of probation violation allegations, Mr.
Yes.
All right, thank you. That means that the court is limited to a sliding scale of potential punishment. Now, typically that sliding scale for felonies would be, because you got one felony in here, would be 15 days, 30 days, 45 days for your first, second, or third. However, the question is will I treat these as one series of transactions? That will just be something. Yes, sir?
My understanding is realistically, it's not going to change anything as far as our recommendation or something, but violations of no contact orders, I think they're non-tax.
Oh, yes. You know what? They are. The only thought here is, as I'm sitting here, I was wondering, how do we have a no contact on a drinking and driving?
There was a domestic.
Was there a domestic involved?
Domestic violence. Yes.
Okay. All right, then, the answer is yeah, they would be non-technical. So now that's important because the court's no longer limited to that sliding scale. The court would only be limited by the amount allowed under the law for the original offenses. Now that I told you what your rights are and possible consequences and the charges, I need to see how you wish to respond. First of all, do you wish to have Mr. Hartel represent you?
Yes.
All right, thank you. The court therefore initially enters a not guilty plea and refers the matter to the public defender's office, and well, bam, there he is. He's now representing Mr. Young. Great. Mr. Hartel, why don't you tell me what the two counsels here have worked out?
Yes, Your Honor. It's my understanding that the people would be offering to reduce it to one count. And if my client pled to that, they would also not be objected to the court considering lifting the no contact order. It's my understanding the victim is present with the victim's advocate. If the court had any questions for her.
Okay, well, we'll have questions for her in just a moment. Is that correct, Mr. Ringstrom?
That is correct, Your Honor. And just so the court is aware, on May 4th is when he put the plea out. At that time, the victim had requested the no contact order being lifted, and it was lifted at that time, but then it was added as a probation condition afterwards.
Oh, so the term or condition of bond had been lifted, but then it was added as a probation condition.
Yes, Your Honor.
Copy that.
No one brought that up at that time.
Well, all right, Mr. Young, is that how you wish to resolve today?
Yes.
Please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, whole truth, nothing but the truth?
Yes.
Thank you. You may lower your hand. So if you make an admission on one of these counts, we're going to dismiss the other two. Do you understand?
Yes, it is.
If you make that admission, you're going to waive your right to have a contested hearing. Do you understand?
Yes, I did.
Has anyone made any promises, threats, or inducements to force or compel you to make that admission?
No.
And has anyone promised you exactly what I'm going to do?
No.
Knowing all that, do you still wish to make the admission?
Yes.
So we're just going to look at count one. The court first takes judicial notice of the terms and conditions of your probation that are contained here in the court file and that were signed by me on or about July 7th. That's pretty fast. And looks like they were acknowledged by the defendants. On July 8th, the day of contact. Okay. Well, did you sign them before you made the phone call?
I believe so, yes.
Okay, good. So is it true you reached out and had a contact with this person, Katie?
Yes.
All right, thank you. Any objection, Mr. Ringstrom?
No.
Mr. Hartel?
No, Your Honor.
All right. The court finds the defendant guilty of count one. Counts 2 and 3 are hereby dismissed. Katie, why don't you come on all the way up here to this podium, if you would, please, for me, ma'am? And how badly did I botch your last name?
You got it right.
I did? All right, great. All right, Katie, is this true? You apparently had requested that the bond condition be lifted, and you're now requesting that the probation condition to not have any contact should also be lifted? All right, has anybody threatened you, coerced you, do anything to make you lift that?
No.
All right, you're doing this of your own free will? Yeah. All right, do you want to have contact with him?
Yeah.
All right. There you go. Thank you very much, man. Any further recommendations on behalf of the Department of Corrections, Mr. Blazak?
Oh, yeah.
Okay, you sure?
Yes.
You look like you're looking around. All right, Mr. Ringstrom, how about you? What's your input?
I mean, technically he did violate the court order. He should have handled things differently. A motion should have been filed instead and trying to lift this and all of that. But based off of the victim, he's already serving still jail time.
Oh, he's still in jail for this. He's still
in jail for, I think, another 30 days or something like that.
That answers my question about how y'all caught it, because it was over the jail recording system.
So over the jail recording, so we knew that he existed. So we're staying silent as far as whether or not the no contact order is lifted, but based off of what the victim says, I think we should.
Mr. Hartel, I'm going to help you here. I'm going to make you look really, really good. Okay? Not that you don't look good all the time. And I say that professionally. I'm not going to do anything. Do you want to speak and allocute and maybe trick me and make me go the other way?
I'm not going to try to talk myself out of that. No, Your Honor.
Good enough. How about you, Mr. Young? Do you want to say anything?
Just we're going to have contact with my fiance and kids.
Okay. Copy that. Thank you. The court is just going to merely let this probation violation echo. Yeah, there it goes. It's done. All right. I'm not going to add any jail time. I'm not going to add any extended probation. So that was it. All right, good. Now, oddly, I have to give him some advice of rights for it, because technically he has the right to file an appeal to what I just magically did. Mr. Hartel, you need to take it out to him. It seems really, really silly. This is probably one of the silliest things I've ever had to do in a while. You have the right to appeal what I just did. If you choose to, you're going to fill out one of these forms. There's two of them there. You're going to put your initials on one. Doing so merely acknowledges receipt to the other. This document tells you that you have the right to appeal the conviction and sentence in your case, as well as this horrific probation violation sentencing that I just gave you. And if you choose to do so, and you want the court to appoint an attorney to appeal, first of all, I'll check to see if you're sane, because that wouldn't make a whole lot of sense. But if you do, you fill out the bottom half of the copy that you're taking with you and return to the court within 42 days. If you choose not to appeal, then simply dispose of it, throw it away. Do not put it in the toilet at the jail. It will flood the system and you'll get in trouble for damaging property. All right. Any questions, Mr.?
So I'm able to have contact with him?
Yes, we're going to remove, I'm sorry, I should have said that. We're going to modify the terms and conditions of probation and strike that term. Thank you very much for that question, Mr. Young. You are free to speak to one another. I thought maybe I hear claps and cheers, but I didn't. That's okay. Thank you, Mr. Young. All right. Yay. Love. We're adjourned.
Thank you, Your Honor.
So you're basically doing no jail.
No jail, no extension, modified bond conditions to strike that condition. Well, whatever it was, something or other. Thank you.
He's so goofy sometimes. Alrighty, friends, TCF Live on this Super Friday. Let's go to Florida. Wade Mercer.
Sergeant Corporal.
Yes, Your Honor.
I gave you promotion while you were out. We
Yes,
do have
sir.
one person. We have one person that has friends or family here, so let me take that case first. That's Hannah Reed. Miss Reed, good morning. Miss Reed, your sister and a couple of friends are here in the courtroom, ma'am. You've been accused of one count of felony battery. Miss Reed, there is probable cause in the complaint. I have read your criminal history, which reflects several prior charges, ma'am. I think you're entitled to a bond as far as I can tell. I'm going to listen to the attorneys and I'm going to address your bond status. Mr. McDaniel, anything?
Your Honor, we just asked for a reasonable bond.
Thank you. Mr. Mitchell.
Nothing at this time, Your Honor.
Ms. Reed, this is a third-degree felony that you're accused of. I'm going to set you the normal bond I would set in most third-degree felonies. That bond's $5,000 cash or surety. Cash or surety means you do not have to come up with all the money. A surety bond is where you would go through a bondsman, and if you go through a bondsman under Florida law, they charge you 10% of the bond. That'd be $500 is what it would cost you to get out of jail. Ms. Reed, you have a condition of no contact with the alleged victim. Ma'am, you're going to use the phone in just a few minutes, ma'am, to try to post the bond. Ms. Reed, you also will be given a notice for your court date. Still going to be August 4th.
I think so.
The jail will give you a notice for your court date August 4th at 8:30, and they'll give you that written notice. They'll put it in your hand before you leave the jail. Ms. Reed, you will not get a notice in the mail. That notice they put in your hand will be the only notice that you receive, so make sure you keep up with that. Ms. Reed, do you have any questions?
No, I don't have no questions.
Let me see if your sister has any questions. Any questions in the courtroom? If you go through a bondsman, the bondsman by law, they charge 10%. Some bondsmen will work with you on that 10%. They may take some up front, some back, some later. They also will look at her criminal history, and some bondsmen will say, based on her history, we're not willing to take that risk. We're not going to post bond for her. So you gotta choose a bondsman and then try to figure out if that's what you decide to do to get her out. Okay. All right. Wish you the best, ma'am. Thank y'all for coming.
Thank you.
We have someone just came in to first appearance. Are y'all here for a first appearance case? What case is that? I'm sorry, I couldn't hear you.
Treson Singleton.
Treson Singleton. And I want to tell him who's here. So what's your relationship? So I can tell him who's here. Mom. Mr. Singleton, your mother's in the courtroom. You're here because you've got two things. You've got a violation of pretrial intervention warrant. In addition to that, you have a new charge of battery. I've read the complaint on the new case. There is probable cause for that charge. I think you're entitled to a bond on the battery charge, although you're not entitled to a bond on the violation of pretrial intervention and violation of conditional release. So you've got one case with no bond. You've got a separate case that you are entitled to a bond. So I'm going to listen to the attorneys, and then I'm going to set the bond in the battery charge. Mr. McDaniel, anything?
No, Your Honor.
Mr. Mitchell.
Your Honor, we just need time to get in contact with the alleged victim as it pertains to the battery. It's up to the court if you want to go ahead and resolve the PTI today, but I know you usually like to resolve them both at the same time.
I don't really see a point in doing that. So, Mr. Singleton, your bond's going to be $5,000 cash or surety on the battery. You have a condition of no contact with the alleged victim, but don't try to post it because you won't get out anyway, because that warrant that was already signed weeks ago has no bond on it. So he's got no bond in one case and a bond in another case. Let me see if your mom has any questions, and we're going to give you a court date. Any questions, ma'am? No. Mr. Singleton, your court date will be
August 12th.
Yeah, I think August 12th.
August 12th will be your court date. And we may see you before then. Mr. Mitchell will interview the alleged victim or attempt to interview the alleged victim in the new charge. But the violation was filed against you before the new charge even happened. So the new charge is not what's allegedly violated your release. That may be amended and it may be added to it. But according to the release paperwork, once you got on PTI, I think he never reported back at all, did he, Mr. Goodson?
2 months or so.
Oh, so there's been a warrant out for you since May of 25. So we're going to see if we're going to be with us for a little while. Do you have any questions at all, Mr. Singleton?
And y'all don't do house arrest?
Not on misdemeanors, no, sir.
All right. All right.
Your mom has a question. Yes, ma'am. Yes, the charge he was on. What was the charge he was on? Pretrial intervention for?
Resisting without violence.
The charge he was on for was resisting without violence. He disappeared in May of 25, April or May of 25, and we haven't seen him since until he got arrested yesterday. Okay. All right. So we'll see you in the next few days or on your court date. Thank y'all for coming.
All right.
Yes. August 12th, but ma'am, Mr. McDaniel is very proactive, and he'll keep, once he speaks to Mr. Mitchell, it's not unusual for that case to be brought up earlier. So if Mr. McDaniel can get it resolved to your son's satisfaction, I may see him before then if his attorney brings him up. That's certainly possible. So just stay in contact with your son at the jail, okay? Yes, ma'am. We have Daniel Godwin. Mr. Godwin, good morning. Mr. Godwin. Good morning. There's a motion filed in your behalf, but I don't know if there's a notice of appearance or not. Let me look and see. Mr. McDaniel, you probably looked already.
I did not look, Your Honor. I apologize.
Okay. No, it's okay. I don't want to do anything without his attorney being here if he doesn't want me to. Mr. McDaniel?
I did see that one of the cases they didn't file on, so I did look at that, the protection of minors. So they charged 3 felonies. The fourth one they did, or the third of the 4 charges they did not file.
I noticed that. That was very unusual. The state was involved in reviewing the warrant, and 4 days after they reviewed the warrant, they dropped one of the charges and filed the other 3. So they must have got some additional information. But let me see if that attorney filed a notice of appearance or just filed a motion.
It looks like there was a notice of appearance filed back on October 29th of last year.
Yeah, so you've been in Leon County Jail dealing with a charge there, correct, sir?
Yes, Your Honor.
Okay, so your attorney did file a notice of appearance, and that attorney was
Douglas McAlerney. I don't know how to say that last name.
Yes, that's right.
Okay, so the attorney's filed a notice of appearance. So what I'm going to do today is I'm going to go ahead and set your bond. I don't want you sitting there with no bond. Then your attorney can talk to you about if you want to file a motion for a bond reduction or have another judge look at it, the presiding judge, that's fine. So as Mr. McDaniel said, you were accused of 4 charges, but one of them has already been dismissed by the state. That leaves 3 charges. So Corporal, the protection of minors, prohibition of certain acts in connection with obscenity, that's count 3. That case has already been dismissed by the state. So you don't have to post a bond on that. You're not being held on that charge. The other 3 charges are unlawful use of a computer to solicit a minor to engage in unlawful sexual conduct. That's a 3rd-degree felony. The second charge is unlawful use of a 2-way communication device. That's a 3rd-degree felony. The 3rd charge is transmission of material harmful to minors by electronic device or equipment. That's a 3rd-degree felony. So you have 3 3rd-degree felonies. I've reviewed your history. It appears you actually were in a drug treatment program and had pending charges or on probation, one or the other, when this charge happened. So that's the factor I'm going to consider for bond purposes when these charges happen, plural. That's a factor I'm going to consider for bond purposes. But I'm going to listen to the attorneys and see if there's anything else I need to know before I set the bonds in those cases. Mr. McDaniel, anything?
Nothing, Your Honor.
Mr. Mitchell?
Nothing, Your Honor.
Okay. Sir, your bond's going to be $10,000 on each count. You have 3 counts remaining. Your bond is $30,000 cash or surety. You have a hold for Leon County, but the best I could tell, you resolved that case. You just have a few days left. Is that right?
Yes, Your Honor, that's correct.
Okay, so they have a detainer. If you post bond immediately, you'll have to go to Leon County to finish that sentence. If you don't post bond, then what will happen is Leon County will release that detainer on you when they calculate that you've served the sentence, and then you'll be here on our charges only. You do have a condition of no well, actually, there's no alleged victim because that was a undercover officer. So there's no person to keep you away from. Mr. Mitchell, any other requested special conditions to the bond?
Maybe
I think this was not. It was a texting. I think I don't know that it was the type of thing you would keep the internet away because I think it was a phone.
I don't know if the court can do that, but have a condition that he not access the app that was used in that situation.
Do you know what app that was?
Hold on just a second.
I don't know if it may say it. Sometimes it tells us that. Sometimes it doesn't.
What was the monetary amount though?
30,000 total, 10,000 each, 3 counts.
Particular social media and dating website such as skipthegames.com, I think is what it is.
That was the thing that was allegedly used in this one?
Yes.
And you're requesting he not be allowed to use that access that app?
Yeah, I guess.
Mr. McDaniel, any objection to that condition?
No,
no objection, Your Honor.
Okay, so you're going to have a condition of your bond that you cannot use that particular website, skipthegames.com?
Yes.
I'm saying that right, Don? Mr. Goodson, I know you know. All right. So, Mr. It's Godwin Denyo. Denyo is the last name, correct?
Yes, Your Honor.
So, Mr. Denyo, you'll get to use the phone in a few minutes to try to post the bond. You also will be given a notice for your court date. The jail will give you that notice for August the 4th at 8:30. And that'll be your first court date in front of Judge Garcia. Do you have any questions?
Yes, Your Honor. I have 2 questions. My first question is with 30,000 with the bondsman, that would be 3,000, right?
Correct.
Okay. And then my second question is I'm from Tallahassee. So if I do post bond, can I move back to Tallahassee? And
absolutely, yes.
Okay.
Yeah, there's no when you're accused of a crime, you're not convicted at this point. You may not be convicted. There's no prohibition on you living wherever you want to live as long as you don't miss your court dates, as long as you don't have any contact with anyone you can't have contact with. That really doesn't apply to you, and as long as you're not charged with a crime. So
okay.
I don't know. Now it looked to me like you're no longer on probation. They terminate your probation and sentence you to a year in jail, right?
Yes, Your Honor, that's correct.
So you live wherever you want to live. As far as this case is concerned, if you have other cases or issues going on, all I know about is the violation of probation charge that you got that resolved in the case here. But there's no restrictions on where you live in Jackson County in the Jackson County case. Any other questions?
No, Your Honor. Thank you.
Wish you the best, sir.
Thank you.
Yes, sir. Schuler. Mr. Schuler, good morning. Mr. Schuler, you have a hold out of Liberty County Mr. Schuler, I tried to find what that warrant was for so I could give you a little more information, and I couldn't find it. It must be in their local sheriff's department system. A lot of times they don't put them in the statewide system until the warrant is actually served. So all I know is it's a case number of 26-633, but it's not in the statewide system yet because the warrant hadn't been served until yesterday. But Liberty County wants you. They say they're going to pick you up for whatever this charge is. Do you have any questions?
No, sir. As far as I know, it's for a misdemeanor paraphernalia charge.
Yeah, it doesn't say 633 CF or MM. So you could be right. I don't know if it's misdemeanor or felony. I just know it's 26-633. And it's not showing up in our statewide database, which means it's only at their sheriff's department right now.
Okay. Sheriff's Office case number. I doubt it's a felony case number because I doubt Liberty ever gets up to 633 cases, but.
I didn't think about that. You're probably right. It's either going to be a misdemeanor or sheriff's department case number because that is a pretty high case number for a small county.
Yeah.
All right.
Thank you, sir.
Wish you the best, sir. All right, Mr. McDaniel, that's everything I know about this morning. As far as first appearances go, anything else from the public defender's office?
No, Your Honor.
Mr. Mitchell, anything else from the state?
Nothing from the state, Your Honor.
Corporal, anything else from the jail this morning?
No, Your Honor.
Ms. Williams, Mr. Gibson, anything else?
Alrighty, friends. It sounds like that's the end of Judge Mercer's day. I hope he has a good weekend. Good morning to all of you, TCF Live on this Super Friday. Probably some new people out there, judging by the current stats. If you're new to the channel, do please take a moment, say hi to us in the chat. We're friendly folk. You've stumbled into a very good community here. Let's go back up to Michigan and back to Judge Elmore, new contestant there.
You missed it yesterday. Mr. Harrison and I were doing a duet.
Really? Oh, man. Wish I could have seen that. Or heard it.
All of me from Nelson Stardust out there.
Oh, that is the best album. I love that. What song were you doing again?
All of me.
All of me. Why not take all of me? Can't you see no good without you?
Your Honor, do you have a probation violation recommendation?
I do not. I'm looking for it. And that's exactly what I'm looking for. I don't.
We had requested it yesterday and got it like around 4 minutes, so I don't know.
I may have left the office half hour early. Let me know when you're ready there, Robert.
We're ready whenever the court's ready.
Okay, great. All right, we're next taking up the case of People of the State of Michigan versus Dana Alexander Scott. File numbers 26-3657 FH. Appearances, please.
Thank you very much, Your Honor. Attorney Robert Ringstrom, Assistant Prosecutor for Missaukee County.
Robert Hartzell for Mr. Scott, who joins me today, Your Honor.
Thank you. Also here this morning is Mr. Luke Blazak. He's the agent from the Michigan Department of Corrections here today. We're here for a sentencing on a probation or set of probation violations. The defendant resolved them with a plea of no contest to count one, and then the remaining counts will be to be dismissed. Is that correct? Correct, Mr. Blazak?
I thought it was like counts 6, sure.
Well, I'm looking at the form, the journal form that the clerk gave me, but it could be incorrect. Looks like he pled guilty, no contest to count one, or violating Rule 1, and the others were dismissed.
Yes. Yeah.
Okay. All right, yep, we got it. Thank you. All right, so I've got the recommendation here. Any objections to the content therein, Mr. Mercer?
No, Your Honor. There's no full verification of it yet, but we had heard that charges have been pressed in Wexford County now, but.
In which county?
Wexford.
Okay.
That is accurate, Your Honor.
All right, thank you. Mr. Hartel, any corrections or anything we need to address here?
No, Your Honor, after sidebarring with my client about it, we don't have any corrections to it, no.
All right, thank you very much. Is he currently, all right, the sentence was issued back in April. He had only 38 days left to serve, so he must have served that, then he got arrested on the requested warrant?
That's correct, Your Honor.
Okay, and are the new charges already filed?
They are, is the bond 50,000? I'm not sure. I'm not sure exactly what the bond is, but they have been filed in Wexford, yes, Your Honor.
Has there been an arraignment though?
There has, Your Honor.
Okay, thank you. All right, well, let's go ahead and jump. There's no challenges to the content. Let's go ahead and jump to allocution. Mr. Rickstrom, what do you think?
I think that the defendant here needs to go to prison at this point in time. He's sitting there. The original charges, he's following people, taking pictures of them naked, stalking them basically, and all of that stuff. One of those victims was a 10-year-old girl, and here we are now, just within 30 days of his being released. He has more photos of that, very bad photos of young children on his phone. I think at this point in time, he has shown that regardless if he gets released again, he'll just do the same thing at this point in time. So I agree with the recommendation. I think that he should go to prison. I don't think that him being watched by us is going to help much.
Mr. Hartel.
Thank you, Your Honor. I know we entered no contest here, plus those charges are pending presently, so I won't overly allocute to the exact specifications of what there's a finding on that occurred. What I will say is I have met with my client, although I would encourage him not to make too many statements today for those reasons. He's cognizant of the fact that he needs mental health treatment. He wants to make sure he's not in front of the court again without doing any additional statements into depth. But he is very much aware that he needs help. He wants to get that help. And we're hoping that if he goes to prison for a short sentence, that he can get that help there.
All right, thank you very much. Mr. Blazak, could I see the previous PSI? Thank you. Now, Mr. Scott, I understand, I don't, because that you entered a no contest plea, I don't anticipate in most of those instances that a defendant's going to say anything, but because you've got those other charges pending. So if you don't say anything, that's perfectly fine. I'm not going to take it and apply it negatively, but I just need to let you know you have the right to make a statement if you choose to do so. Is there anything you wish to say?
Only to reiterate what my attorney has said, that I do severely need mental help, and I have for many years.
Sure.
Just lack the ability at one point or another, for one reason or another, to seek it.
Sure. I understand. Well, you know, I'm not taking away from the importance here, difference in distinction between this and other things. Everybody has, at least most will seem to have some kind of drive, action that they're often unable to control, and because it's part of them, whether it's alcohol, gambling, chocolate, I don't know, especially dark chocolate for me. Woof. But anyways, and I'm not trying to say that that's the same thing here, but the point here is just your acknowledgement of that is a good step. I really appreciate that, and I think that can be helpful for you. All right. Well, the next challenge I really have here is the processing of the other case. I mean, if I send him to a prison, he's not here to be, makes it more difficult. But at the same time, the sentence isn't supposed to necessarily try to consider what's helpful for the prosecutor and defense attorneys. It's really to help the defendant. And I know if we leave him here, there's really no healthcare. There's no mental health treatment here in the Stockton County Jail. I'm not picking on the sheriff's department or the county. That's just the way it is in small parts, the smaller counties in Michigan. We don't have that kind of treatment. We don't have it available. Mental health is really only going to come down if there's an emergency, like a suicidal ideation, things like that. But they rarely have the time and money or funding to be able to do everything that's needed of them. So that's not picking on them. It's just a part of reality. So I want to help the defendant get the help that he needs. To me, that is priority number one. He has had some impulse control issues in the past. We see the retail fraud, some violent actions in the past. So I am concerned here about impulse control. The court therefore sentences the defendant as follows. The court sentences the defendant. It's within the guidelines. While the guidelines are an intermediate sanction, the court finds, based upon the violation here in the file, that there are reasonable grounds to give further confinement. The court therefore sentences the defendant to a prison term of 16 to 48 months for count 1, the possession of CSAM, and for count 2, which is surveilling an unclothed person, the court sentences the defendant to 16 to 24 months. That, of course, is the most that I could do on that. That is outside of the guidelines, but I find it to be a reasonable proportionate. And it's at the 2/3 level. So that's the highest the court could ever go anyways. The court awards the defendant 200 days of credit. Any fines or costs ordered previously are preserved. And again, probation is terminated unsuccessfully. Have I missed anything, Mr. Blazak?
I don't believe so. Thank you, Your Honor.
Mr. Rickstrom? All right, Mr. Hartel is going to bring to you, Mr. Scott, 2 copies of one document. This document you've already seen before. You're going to place your initials on the first copy. Doing so neither elects nor waives any rights. It merely acknowledges your receipt to your copy of the document. This document tells you that you have the right to appeal the conviction and sentences in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal is done by filing an application for leave to appeal. Now, if you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy that you're going to take with you and return to the court within 42 days. If you choose not to appeal, you may simply dispose of your copy of the document. All right. Mr. Scott, thank you for your acknowledgement today. It's not really acknowledgement as far as your Fifth Amendment rights in the other case, but what I mean is I thought your words were insightful. They were short, but they were insightful enough. So I sincerely do wish you the best of luck. Anything else, Mr. What's your name again? Hartel. Thank you. All right. Anything else besides that document? All right. Thank you. We're adjourned. Mr. Blazak, yours.
Alrighty, friends. TCF Live once again on a Super Friday, entering hour number 2 already. Let's stay in Michigan, but let's check back in with Judge Anzalone.
H in the matter of Huston Eric Owen. Miss Underwood, I've been advised that no writ was prepared to get him here. So we are going to have to reschedule that sentencing, and I apologize.
Oh, no. Okay. Thank you.
Thank you.
Judge, do we have
all
a
right,
date?
Mr. What, Ms. Teskey?
Do we have a date by chance for Huston?
I don't have a date. Miss Adams, do you want to give us a date?
I will set this for July 30th at 8:15.
July 30 at 8:30?
8:15,
Thank you, Your Honor.
All right, July 30 at 8:15. All right. All right, Mr. Wade, grab your report. All right, this is file number 2025-22446FH in the matter of the people of the state of Michigan versus Christopher James Wade. This is the date and time set for sentencing in this matter. I have Brian Fry appearing on behalf of Mr. Wade. Mr. Fry, you did receive a copy of the misdemeanor PSI, correct?
Correct, Your Honor.
All right, Mr. Wade, you're able to hear me, correct?
Yes, ma'am.
All right, Mr. Wade, did you get an opportunity to read and review the pre-sentence report?
Yes.
Have you had an opportunity to discuss that with Mr. Fry?
Yes, ma'am.
Are you satisfied with Mr. Fry as your attorney and the advice that he's given you?
Yes, ma'am.
Mr. Fry, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, Your Honor.
Does the pre-sentence report, well, I don't think they even list them. Oh, yeah. Have any prior convictions in which there exists any known constitutional defect?
I don't believe so, Your Honor.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Wade?
Yes, Your Honor. We would ask that the court follow the Killebrew agreement in this case to no upfront jail. My client has limited criminal history, looks like a handful of misdemeanors, no felonies. And, you know, two of the misdemeanors are from over 20 years ago. He has been having some issues with his phone lately. It was disconnected. My understanding is he just got a new phone number turned on yesterday. So he's already provided that information to the probation department. So, you know, he'll be able to be in contact with them. He has been successful on probation before. We believe he'll be successful on probation this time as well. He does live in Lenawee County in Onstead. The one potential issue we have with the PSI, Your Honor, is this restitution amount of $13,672.28. I have no idea where that's coming from. I know the PSI notes that a co-defendant got restitution for that amount, but so I know that's where they're pulling it, but I'm not sure where that number originally came from, as there was no mention of any damage in the police report, and there was no invoices or anything attached to this. So we'd be asking for a restitution hearing on restitution. But other than that, we'd ask that the court sentence my client to a term of probation and follow the no upfront jail Killebrew agreement. Thank you.
Okay. And obviously, if co-defendants are assessed a restitution, it's joint and several. But will you call and schedule a restitution hearing with my assistant then?
I can do that, yeah.
All right, you do have a right to a restitution hearing. Mr. Wade, is there anything you'd like to say on your own behalf?
No, ma'am.
All right, in determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing, the criteria and reasons for the sentence on the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for law, and protection of society. It's a sentence of the court. It'll be placed on probation for a period of 24 months. Obviously, it's a lengthier period due to restitution, but if you were to pay everything off, obviously you could be released from probation earlier. There's a $250 fine, $50 in state costs, $75 crime victim rights fee. I'm going to order $500 in court costs. There's a $30 per month supervision fee, $60 if we have to put a tether on you, but we don't typically do that on misdemeanors. There was, let's see. I'm not seeing a no contact or anything of that nature. So, Mr. Wade, I'm gonna have you report to the probation department next Thursday morning between 8 and 10. If you fail to appear for that, a warrant will be issued. So it's very important. I know you kind of probably played phone tag or didn't get to talk to the probation department, but it's very important that you be there next Thursday between 8 and 10 a.m. You're also going to receive in the mail from my office an envelope, and in that envelope will be 3 copies of your notice of right to appellate review. 1 copy will be flagged for you to initial and date. I need you to initial and date that, fold it up, and then there will also be a self-addressed stamped envelope. Put that in that envelope and just put it in your mailbox and get it back to us. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. Any questions, Mr. Wade?
No, ma'am.
Okay, very good. Anything else, Mr. Fry?
Nothing further.
All right, thank you, sir.
Thank you.
Thank you, Your Honor.
Thank you. Mr. Noe, I know you're here. I'm taking everybody in order of how they got here, so you'll be next after I finish Miss Underwood's case. All right.
Thank you.
Yep, not a problem. All right, we are back on the record in file number 26-22517FH in the matter of the people of the state of Michigan versus Drayton and Glaspie. Mr. Wade, I'm going to help you on your way out of here.
Thank you.
You're welcome. Sarah, could you mute your device because we're picking up background noise? Someone in the hallway or something. Okay, thank you. All right, so Miss Underwood, you had ample time to speak with Mr. Glaspie.
Yes, Your Honor, I have.
So, Mr. Glaspie, have you had an opportunity to read and review the pre-sentence report?
Yes.
Have you had ample time to discuss it with Miss Underwood?
Yes.
Are you satisfied with Miss Underwood as your attorney and the advice that she has given you?
Yes.
All right, Miss Underwood, and this is a Jen Walsh file. Miss Teskey, you are filling in for this.
I am, Your Honor.
Thank you. All right, Miss Underwood, do you wish to explain or challenge the accuracy or relevancy of any information in this pre-sentence report?
We really don't, Your Honor.
All right, does I show he has 2 prior felonies, 1 prior misdemeanor. Does the pre-sentence report disclose any prior convictions in which there exists any known constitutional defect?
It does not.
Probation Department has computed the minimum sentencing guidelines to be 0 to 9 months. Do you agree with that computation of guidelines?
I would agree with that.
All right, before the court passes sentence, is there anything you'd like to say on behalf of Mr. Glaspie?
Very much so, Your Honor. Glaspie, I think throughout this process, has recognized that he has a decision to make, Your Honor, and that is how he's going to spend the rest of his life. Is he going to spend the rest of his life in a constant merry-go-round of police involvement and courts, or is he going to take the opportunities he's given and make something of his life, Your Honor? And I'm really pleased to report that I think he's doing the latter. Mr. Glaspie is going back to school to try to build on his 1 year he has of college. He's also starting employment opportunities with certainty next week. What is certainty, Mr. Glaspie?
It's a warehouse where you package and deliver, like, kind of like an assembly line.
Very nice. And Mr. Glaspie has resolved all his other issues. So that means he can come in, he can get his probation documents, and he can start probation, Your Honor. I know there was a recommendation that he do some jail time. I would hope the court would consider deferring that for any violation, Your Honor. I think everything's moving very positive for Mr. Glaspie, and I think we should build on that. And I wish him every success.
Thank you. Mr. Glaspie, is there anything you'd like to say on your own behalf?
No, Judge.
Okay. In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and protection of society. So, Mr. Glaspie, I'm glad to hear that you are taking positive steps. You know, it is definitely in your best interest to do that and kind of change this path. You're 23, you're so young. And so, you know, you have a long life ahead of you, and I'm glad you're making those efforts. So I'm going to place you on probation for a period of 12 months. During that term of probation, you will obey and comply with all the articles of your probation. Obviously, what county do you live in?
Jackson County.
You're in Jackson County? So yeah. Ms. Teskey will transfer his probation to Jackson, right? Yes. Yeah. So your probation you'll have to come in here one time and meet with our probation department, and then they will transfer that to Jackson. I know you have like a 24 and a 25 case, but neither of them are in Jackson. One's in Ohio and one's in Wayne.
Yeah,
Did they transfer your probation?
Sorry to interrupt, but I'm doing the Ohio case down here in Jackson. So
okay, so they'll transfer this case to that too. All right, good. All right, so you know, obviously the requirements are not to commit any crimes, not to leave the state without consent, comply with all testing. I'm not going to okay, there's no term in here, Miss Teskey, for not to use any alcohol, and I'm not going to add it. It does require testing, but it doesn't say he can't use alcohol. But Mr. Glaspie, you're not to use any illegal controlled substances, use all prescription medication as prescribed, have any assessments or counseling as required, report as often as required to the probation department. I'm going to order 20 hours community service work. You work full time, so yes. I don't think 120 would be feasible. Obviously, you have to notify your probation officer of any change of address or employment, obey all court orders, not engage in any assaultive, abusive, threatening, or intimidating behavior, not to use any object as a weapon, comply with any written or verbal orders made by the field agent. And you understand that probation officer can enter your home at any time for probation supervision, but they also can search your car, your phone, your home, if they have any thought that you have anything to violate the terms of probation. I am going to give you credit for 8 days already served. I'm not going to order jail time on this, but understand if you violate probation, you probably get jail from me in Wayne County and Ohio. So it all rack up. There is restitution in the amount of $1,000 to Connor Cable. A crime victim assessment fee in the amount of $130. There's a $30 per month supervision fee. I don't know how that works, Ms. Teskey. If he's got multiple files through Jackson County, does he pay one for each file or just one?
Your Honor, our fee collection, you just need to order it. Our fee collection unit will only assess it one.
Okay,
but
good.
They'll figure that out.
All right, there's $750 in court costs. I don't think I need to order the DNA fee because you already had it done in Wayne County, and there's $68 in state costs. Mr. Glassby, as I said, you're very young. A lot of times what we see is people getting in trouble. They rack up these fines and costs that are mandated by the state, and then it just becomes overwhelming. And so I'm glad you're working full to pay it off. Obviously pay it off, and you stay out of trouble, they can release you early. All right?
Okay.
Now, Mr. Glassby, you are going to have to come here and report to probation one time to fill out the paperwork to transfer it to Jackson County.
Okay.
What are your hours that you work?
Monday through Friday. Well,
What time?
I haven't started yet. It's going to be starting. I'm going to start next week, but Monday through Friday.
What day do you start next week?
On Monday.
Okay. What time do you go in, you said?
9 o'clock? Yeah, 9 o'clock.
So, Ms. Tusky, I don't want him to lose a new job. So I don't know how we can try to work this out.
I don't know either, Judge. He's got to come in and be orientated. There's no way around that.
So could he come in today if he came here now?
No, because it takes us a little bit to get this order of probation generated. Once we get all the paperwork back from your office, it usually doesn't. It's usually takes a little bit.
Okay. All right. So yes, Mr. Glassby.
Can I just let my job know that I can start on that next day instead of that Monday, if we can just work everything out?
Typically, Ms. Teskey, would it be Tuesday he would report?
Yes.
So we
Mr.
would need
Gillespie,
you
what
here.
time do you get out of work?
It would be like right before the court closes, so like 3:30, 4 o'clock.
Okay. What I want you to do is at 8 a.m. on Tuesday morning, I want you to call Miss Walsh. And you and her are going to have to figure this out.
Could you be, if he got here right at 8 o'clock on Tuesday, how long would it take?
15, 20 minutes.
So, Mr. Glassby, if you could if it would be okay with them, you could be a little late on.
Yeah.
If you got here right at 8 o'clock, I'll ask Ms. Walsh to take you first and process you, because obviously I don't want you to lose a job. And so could you do that? You have a car, right?
Yes.
So you got to be here at 8 o'clock on Tuesday, 3rd floor of the courthouse. I'll get off the elevator, take a left, and on the right towards the end will be the probation department. Be here when the courthouse opens at 8, and Ms. Test will leave a note from Ms. Walsh, and that way we can do your paperwork, get you transferred, and you should be all set. Okay.
Okay.
Now, Mr. Glassby. No, that's only for out of state. Okay. So Mr. Glassby, we're going to mail to you at the address we have for you 3 copies of your notice of right to appellate review. There's also going to be an envelope that's self-addressed and stamped to return to me in that envelope. One of those copies will be flagged for you to initial and date. Go ahead and initial and date that, put it in the envelope and mail it back to me, stick it in the mailbox. That's just acknowledging you received your appellate paperwork. If you wish to appeal your sentence, you would fill out the information on the form and mail it to the address listed on the form within 42 days. All right.
Okay.
So, Mr. Glassby, I do want you to succeed at this. So, we'll see you Tuesday morning at 8 o'clock. All right.
Okay. See you then.
All right. Thank you. Bye.
No, thank you.
Bye.
There we go. There's my microphone. A couple of minutes ago, Ellie stepped on one of my power banks down here and shut it off for a second, so I lost half my things. But I'm back now. Good morning once again, everybody. It is TCF Live on a Super Friday. Good to have you all here. Let's go south. Let's go to Texas. We will say good morning to Judge Stevens.
Thank you. Well, it's... Whoa, mama. That's an old one, huh? Well, I just got on the case recently. Well, okay, there's an MTRP. This was originally filed back in 2020, the original indictment. Yes, sir. That's 6 years ago. And she's been on probation since 22. Yes. And deferred or unadjudicated probation. And see, we've got a motion to revoke probation filed June, alleging 8 violations, and the defendant's been on deferred or unadjudicated probation. Yeah. Okay. So what are you asking for?
Just one reset on her.
How much time are you talking about?
2 weeks.
8 years?
I'm not
Not
opposed
8
to,
years.
not opposed to a 2-week reset, Judge. We've extended an offer.
Is 3 good?
That's perfect. 3.
We've extended an offer, Judge.
3 is perfect. Yeah. The offer 5 years TDC so on the MTRP. That was the offer.
Okay.
I know y'all.
Then y'all try to work it out, and if y'all can't, then we'll have a hearing. That's what we do.
That'd be fine.
But let me know. But in 3 weeks, if y'all can't work it out, we're going to go into a hearing on it. Okay.
Yes, sir.
All right. All right. Good luck. Thank you.
So he's still on the tab?
Yes, already sees.
Okay.
I'll say.
You need a
because he already signed.
I see.
Mr. Bennett?
He already signed.
Philip?
And he's here. And I do have his grandmother here, right? Yeah. It's already sent it.
It's not on there. It's not coming up.
I'm 100. You don't have to go back to the date that we were in.
Oh, I see. That makes sense.
I'm 100% sure it's there. Yeah.
What date was it?
That's more than 99.
Let me look at my thing. I can tell you the date. Yeah, the paperwork is done. He already signed.
Okay.
You're
You're leaving now?
Yeah, I already know.
There he goes. We'll never see him again.
Judge, we did the 5-year caps on that.
Okay, as soon as I figure out.
Good Lord.
It's on.
Langston, you're on a bunch of these here today, huh?
Yes, sir.
Okay.
Yes, sir. I'm going to tell you right now.
Yeah. Okay. We got Bennett next.
We were in court last on 16/20.
Then,
So check that date.
then we've got,
pop up.
what are we going to do on Jasmine Dudley?
She's here. I think that's going to end up being a hearing.
Well,
Judge,
are we going to do it today?
No, not today, Judge. I'm not prepared. I received the information I needed to file a motion
hearing.
Yes, I received it and we filed an amended MTRP yesterday. He filed it and served it on Mr. Adams just yesterday.
What is it alleging that's different?
We added a new offense, Judge.
Hey, do you have a copy of it? So
I have mine.
Where is Mr. Dudley?
I didn't see it.
Is Mr. Dudley in custody?
Yes, sir. She's here.
Oh, it's Jasmine. Oh.
She's here. Look, let me make a copy of that in the back. Let me be here.
I emailed you.
I'm not saying you.
But I have a motion filed in January. I don't have.
We e-filed an amended yesterday, Your Honor. When I received the information. As soon as I received the information.
What's the
Commit the offense of assault on a public servant in December of 25.
And then I think.
What happened we didn't, that information, I guess, wasn't received.
I just got it yesterday.
When you filed that motion in January?
I wasn't the prosecutor in January, Judge, and I just.
I'm talking to you. I mean, the state, the DA's office.
Yes, sir.
But
it's a new offense.
So, okay. Has it been filed independently as an individual case in a court or anything else? Has it been indicted or an information been filed on it?
It has been, Judge. I have a cause number here of 26DCCR 0428.
Okay, so it was filed as a felony, huh?
Yes, sir.
May I
yes,
see a copy?
Yes, sir.
Have you seen that?
I know about the 2 cases. I didn't know about the amended MTRP.
Thank you.
I just printed out a copy, Langston.
Thank you.
Each copy.
In March.
Maybe. When he filed yesterday, I haven't seen, but you emailed me, so I got to pull it up on my email.
Well, I can clarify. It should have been served, e-served.
Okay.
When last night?
Yeah, yesterday.
I haven't boarded it. I'm not saying you didn't send it. I just didn't. Yeah.
Okay, so in this particular case, so far, The amended motion has not been filed yet.
It's filed yesterday.
Yesterday.
Yes, sir.
Thank you.
Here's a copy for Mr. Adams. We'll get it processed today. It's just filed yesterday, Judge.
Where's my copy?
Well, here, you can take this for right now.
No, I want,
You didn't want
I want mine. Not
I'll
yours.
copy, Judge. Just give me a second.
No, not yours. Hey,
Give me 2 seconds, Judge.
thank you.
Second.
I'm copyless.
Copy.
You know, walking around town like that.
It's not.
Hey,
It's
where's your
not
copy?
good.
I don't
That's
have-
not good. It's
I
not.
don't have a copy. Well, you're copyless.
Hey, you can't beat that.
That kind of, you don't want that kind of stigma.
Well, thank you. Oh, that's original. Give it to him.
Who's on first? Who's on first? Yes.
What's on second?
There you go.
I don't know what's on third.
It's Jasmine Douglas. It's Jasmine Douglas.
And again,
All right.
we just added the new offense.
All right. Follow the press.
Just to make it clear, the defendant is on probation, correct, for harassment of a public servant, a third-degree felony?
Yes, Your Honor.
And then it's alleged that, number one, she committed the offense of aggravated assault on December 20th, failing to immediately report to probation officer a new arrest, failed to never become intoxicated as being intoxicated on or about December 21st, 2025, was at a location other than her residence. It says her residence at approximately 10:50 p.m. on or about December 21st, and finally committed the offense of assault public servant on or about December 23rd. How many assaults were committed that night?
Well, there was one assault on the 20th, December the 20th. And my understanding of the allegation is while she was in custody, the following day was when she assaulted the
Okay, so
officer.
two separate assaults on two different events.
That's the allegation, Your Honor.
And she's on probation for harassment of a public servant, right?
Yes, yes.
Which was alleged. Did assault, harass, alarm, or cause person known to be a public servant or a Baptist hospital employee to contact the saliva of the defendant? So she spit on someone who is attending her medical care?
An emergency room technician.
Okay.
But but Judge, in fairness to her,
I'm just
Right.
looking at what the allegations were here. We hadn't gotten to the whether it's true or not, except she did plead guilty to arrest of a public servant and was placed on probation. So I mean, that's a finding, but the others are still to be found. What's her bond on this?
I do not know offhand, Judge.
And these are assaultive offenses, and she was on probation for assaultive. Generally, the bonds are high.
Judge, I have here the PC affidavit. Well, let me I don't want to miss this. Well, I do have the PC affidavit for the most recent allegation, alleged assault of that correctional officer, if the court's interested.
Judge, on the MPRC, her bond is $100,000.
Right.
Who posted $100,000? You got that money?
No, she didn't.
My family helped me.
Okay, so you have access to that. Are you appointed?
Yes.
You need to be hiring your own lawyer. Well, the taxpayers aren't going to be paying for your legal defense when you can come up with $100,000 bond, man. That's an order. You're going to pay him. He's appointed a great lawyer, but I'm going to make you pay him for what it costs for the people to pay for your representation when you can find $100,000 bond. If you have access to that, you're going to pay for the lawyer fees. Do you understand? That's only fair to the people of Jefferson County. You're not going to pull that.
And then Judge, her bond on the 26 DCCR 0428 is $25,000.
Okay, so you've posted $125,000 in bonds.
But just put that in the context.
I did.
Well, I just want to add something to, what's your name again, ma'am? Mikayla, can you come up real quick? She's a representative of the state of Texas. What Mikayla is the CPS worker on a case because when it's not a hearing.
Well, Judge, it's morphing into a hearing here, and I'm not prepared to.
What are you intending to prove here? So get to the bottom so I'll decide whether we're gonna have a hearing. What is that lady here for?
We're mentioning about the bonds, right? And she has a rich history of psychological issues.
She has a rich ability to get money too.
Right. And I also remind the court that Dr. Rapon did evaluate her. He determined that she was competent. However, he did mention about her mental health issues, that she does have mental health issues that she's been treated for.
Okay.
The reason that CPS is that part of when you were setting those bonds, she also, and Mr. Coleman knows this, I'm not surprising because it's in his discovery. In the discovery that was provided by the state, they mentioned a CPS case, and that's in their discovery. Yeah, it is. It's mentioned. But here's where I'm going.
Where are you going?
So here's where I'm going with it.
Okay.
Yes, it's in that discovery. So I'm not telling him something he don't know. CPS was in favor of her having a bond to be able to get to her kid because as it was going through the case.
Okay,
down there,
that's okay.
Right,
But it's still, I'm sorry, but it wasn't their decision. It was mine. I made the decision.
But
I want to hear as much input as possible and make a fair disposition. So, but what does that have to do with anything else?
Well, here's the point that I'm making. Yeah. When the court was talking about $100,000 and $125,000 bond, part of that is that CPS wanted her out on this case so she can get back to taking care of her child.
Okay.
And what happened?
I made the final decision.
No, you did.
Okay.
But what I'm saying is that she had to hustle and gather resources, and that's why Mikayla can tell you that.
So hey, everybody,
and she's here to say that.
But she's got that. Well, that's fine. But she has resources.
Yeah,
a lot of
that's the state's position as well, Judge. If she can marshal the resources to make the bond, the state's position is she can marshal the resources to pay for an attorney.
Yeah, I'm going to order that ultimately because she has resources and the people are going to pay. You get entitled to be paid because you're a fine lawyer and you do a good job. But the people are not stuck with the tab when the defendants have the ability to get resources. And as far as her other situation that you were talking about, okay, she's imperfect.
Mm-hmm.
Big deal. We all are. Each of us here have issues of imperfection, and some people's phones go off in the middle of the when they shouldn't, right?
But you're right.
But welcome to planet Earth. But you just deal with the imperfections and do the best you can and make the best choices you can. That's what we do. And I wish I didn't make a mistake today. And we all make mistakes. And some of us and all of us have inabilities, whether it's I've got to wear contact lens. I don't have perfect eyesight. Everybody is born with Achilles heels.
Right.
And deal with them.
Right.
And we all deal with them and we do the best we can with what we have to work with. Because our creator gave us enough to work with to get the job done. And it's a test we all go through in making decisions and achievements through our life, in spite of the fact we're imperfect. You're in that boat. There is no reason, I've looked at this, there's no reason why you should be making bad choices. Fix it. If you make a bad choice, fix it somehow. Fix it and don't do that again. That's, and I'm sure that you have children.
Yes, sir.
I bet you told them that.
Yes.
Or where's the, yeah. Don't do that again. And then that's what a form of discipline as a parent to a child, because they go, okay, now I know what the right thing to do. We learn, and we learn through our whole life. Even adults make mistakes. The older adults, and when we make a mistake, we fix it as soon as possible and correct it and do better. Don't do it again. But that's what probation is all about. And we're very excited about the performance that the probation has because I want 100%. We're at 93. We have a 93% success rate on probation. The national average is 75. What does that say? These people are doing their job. They're great in doing their job. I had to tell a bunch of folks about it last night and about how good and proud this county is with our probation office because people, that's 13 out of 14 people do great. 13 out of 14. There's no reason you shouldn't be 13 out of 14, except we're all held to the choices we make. You make a bad choice, you can be punished for it. You make a good choice, you're rewarded. It's simple. And here we put you on probation a while back and it's alleged that you're doing similar things. I don't know why that's happening. It needs to get fixed one way or the other, but your choices here were not well made according to these allegations.
Right.
And why you made poor choices, knowing that it has consequences to it, is what we're trying to get to the bottom of. Because I don't like failure. I wish it was 100%. I really do.
Right, and Judge, and that was another reason why I had CPS here, is that I anticipated, and my understanding from talking with CPS, that the state of Texas, by way of CPS, was going to advocate for her to continue being on supervision. And the reason why is how well she did in her service plan with her kids. She's actively involved in the kids, and that's why
I hadn't heard anything. You know,
she's here.
If
She's
we're
here
gonna,
for.
I'm not
we haven't hearing
I'm
it.
not prepared to go forward with the hearing, Judge.
Yeah,
No,
let's.
I'm just saying what I anticipated that she would have said.
Okay,
if we'd have
but what all that's, I'm anxious to hear it, but she's on probation for harassment of a public servant. She is charged now with assault on a public servant.
Yes, sir.
That's good luck on convince me about that. I don't know what it is, but that's kind of odd. And those allegations are disturbing when if she's charged with similar conduct for which she was charged with before, for which she was disciplined for before, and for which she stated under oath that she would not do again. So that's going to be interesting. But hey, she's presumed innocent. I wrote that article. I'm pretty proud of that. But all of that being said, let's move on. Number one, again, she has access to monies. Those are going to go toward the payment of the people's servant that Mr. Adams is in representing you. If you're able to pay $125,000 of a bond, you're certainly going to be able to pay your public defender here. And that's going to be ordered. He gives us a bill at the end. When do we have a hearing?
Same date, if you don't mind, 3 weeks out, because I got that other guy that you
Good
said.
for everybody?
Yes.
Done.
Same date.
That's it. Thank you.
Thank you. I appreciate it. Hey, I need you back though.
Okie dokie, friends, we'll keep an eye on Judge Stevens' court, but keeping this channel's promise of 9 to 11% more Judge Boyd, let's head over to Bear County, check in with her.
Mike Hernandez. Could I have parties announced for the record for the state?
Right up the state.
Defense.
Tim Molina for Mr. Hernandez.
And are you Mr. Hernandez?
Yes, sir.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Hernandez, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
I believe we are, Judge.
Judge, the state's actually waiving
waiving-
the enhancements.
In that case, Judge, we waiving it. We're proceeding on count one.
All right, thank you. And I'm assuming there's no objection to the waiver?
Oh, yeah, I'm sorry. No objection.
All right, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has been able to assist me in this defense, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Hernandez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 123 days in the Bexar County Jail under 1244. There's a $600 fine. Did you understand that to be the plea?
Yes, ma'am.
Defense and state?
It is plea, Judge. Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
There you are.
Then to the offense, how do you plead?
No
Guilty?
contest.
No contest? State any evidence?
Judge, you have to state exhibit number 1, including all evidence.
No objection.
All right, did you review the waiver and state you may be excused? Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that my client does have, yesterday at least, 123 days in the Bexar County Jail. We would ask the court to consider satisfying the judgment.
The court will find you guilty as previously stated. The court will sentence you to 123 days in the Bexar County Jail under 1244. There's a $600 fine, time and money to run concurrent. Court will give you credit for any time served. There's to be no residing in households with minors. And the court will show that the judgment is satisfied. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so here's the thing. Obviously, you have a drug problem. You need to take care of that. Otherwise, you're going to end up back and forth at somebody's jail or in somebody's prison, or either worst case scenario, somebody's going to be identifying your body because you never know what you're taking. There are plenty of places in Bexar County that can help you. If you're released from custody, because I see that he had a warrant somewhere else.
He's being pulled to Comal. He has a case pending there.
All right. Well, make sure you get help, okay?
Yes, ma'am.
All right. Good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
Alrighty, friends, it is TCF Live on a Super Friday. My name is Dan. It is good to have you all here with me. I'm betting there's some new people out there today. If you have not yet done so, please do say good morning to us in chat. We would love to hear from you. Let's head back up to Michigan. New contestant in front of Judge Elmore.
Versus Aubrey Antcliffe. File number here is 26-3676FH. Appearances from council, please.
Thank you, Your Honor. David Denham on behalf of the people.
I've heard yourself from Mrs. Van Cliff, who joins me to my left.
All right, thank you. Also before the court this morning is Miss Laura Odell. She is the agent from Michigan Department of Corrections who has prepared today's pre-sentence investigation report. We are here for sentencing in this case for which there was a conviction for operating while intoxicated as a third offense. Before we turn to the PSI, I'm going to note that this court received earlier this week a mitigation report prepared by the Public Defenders Program, specifically their social worker, Mr. Brian Heiniger. I don't know if I ever say that correctly, Heyniger. I did go through. It's actually one of the more complete ones. Not picking on the Public Defender's Office, but I'm saying is there's also attachments that included an A attendance records, also several letters from particular people, some related to behavioral health, some also related to her as a person, family members, things like that. And so I went through all of those yesterday, actually. So, all right. Any amendments, corrections, or objections to make to the contents of the PSI, Mr. Denham?
Not for the people, Your Honor.
Okay. How about you, Mr. Hartel?
The only possible correction, Your Honor, is my client advised me she believes she may have 2 days credit. I don't know if the court wanted to look into that or not, but otherwise, no amendments or correction.
Let's see, did she get, so she'd have to be arrested one day and then released after 12 a.m. the next day? That would be the answer to the question. Did you get released? If she got released the same day, it's one. If she was brought in before midnight and then was let out after midnight, that would be two.
Yes. That's the way she remembers it, Your Honor.
I'll go ahead and, hold on. Let me take a look at the file. Yeah, Mr. Denham.
Your Honor, the incident occurred just after 1 a.m., so I don't believe that.
There we go. So that would make sense here. Let me take a quick look at the register of actions from the district court. Yeah, it looks like she was, well, it looks like it was, but it says here posted on the 22nd. Ms. Odell on the register of actions says arrested the 21st, filed the 21st, and then bond was posted on the 2nd. So that would be 2 days.
Is it posted by the court or posted at the jail on that date?
It says $10,000. I don't think any judge posted that. I don't know.
So my records show it was posted at the jail on 4/21, posted by the court on 4/22. I'm not sure if the jail releases the day they receive the bond
Okay.
or
All right. Well,
no
we'll,
objection to another day.
all right, we'll just go. Let's just go ahead and do it. Let's eliminate an issue here. We're going to change that date on CFJ 145, page 2, to read from April 21st, 2026 to April 22nd, 2026. That, of course, increases the days of credit from 1 to 2, and that will be reflected throughout the remainder of the document. Any other I'm sorry, Mr. Hartel, any other corrections or amendments? All right. Mr. Denham, you didn't have any corrections, did you?
I did not.
All right, good. All right. Let's jump into allocution. Mr. Denham, why don't you go ahead?
Sure. Thank you, Your Honor. Your Honor, as the PSI reflects, this incident occurred back in April. The defendant initially called. She had gone off the road. Vehicle was in the ditch. She had left the scene. Ultimately, she was found to have a blood alcohol content of 0.156. Of note, this is the first felony of the defendant. We do support the recommendation. We support the 24 months recommended probation, 480 hours of community service. And as has been noted, the people, whether it be for employment or otherwise, would not have an objection, although it's not a killer agreement, we would not have an objection to the court considering scheduling the required statutory time to be somewhat convenient for the defendant. Again, that would be left to discretion of the court. Yeah. Thank you.
Thank you. Mr. Hartel.
Yes, Your Honor. In addition to what I'm about to allocate, I was reminded by Madam Clerk that my client does have a recovery coach who might be in the Zoom in about 10 minutes. I know we started a bit early, so I'm not sure if the court would want to factor in her
Who's the
statement.
recovery coach?
Kristen Gannon.
Okay. Well, we can wait, or I'll just pretend she's there.
Whatever works.
It's not gonna change.
Oh, all
It's
right.
probably not gonna impact.
We could always let her know later as
Yeah,
well.
yeah, no problem. I appreciate that, but it's not gonna be a negative or whatever, so don't worry. about it. I appreciate, wait, didn't she have a letter in
Wrote
here?
a letter, but she was also willing to answer any questions.
I thought I read a letter, so I was asking for the name. All right, go ahead.
Yes.
sir.
I would ask the court to adopt the weekends. I know she has to do 30 days, even though to some degree, ironically, the guideline range is recommending perhaps even lower than that, but we do realize the law is that way for a reason. Because this was a no contest due to lack of recollection and not civil liability, I do feel I can say a bit more. She does know she wants to avoid this type of situation moving forward. That's why she does do things like her ambitions with recovery. She is looking long-term into perhaps even being, I believe, a recovery coach herself or a counselor of some kind, if I recall correctly.
Yes.
Now, although she is not presently employed in the traditional sense, she does have goals to do that, but she is essentially a full-time caregiver. She has a daughter, without going into too much details for personal reasons, who does have some heart issues, who's on disability. She takes care of her. Her husband, who joins us for moral support in the courtroom, is currently on workman's comp. He had a traumatic brain injury. I won't go into too much detail about that for his personal reasons as well, but she cares for the family at large. I believe there's 3 total kids. Not everyone has a disability, but a young child, it still takes a lot of energy, even those other 2 kids, just being 2 kids. I would ask the court to consider allowing her to be there for her family by preferably on the weekends or whatever days work best for the court. But I'd hate to see her missing a solid chunk of time away from people who love her and need her support. Thank you.
Thank you. Ms. Ankler, is there anything you wish to say?
I know that I have an alcohol problem. I've been seeking help for it. I've been getting lots and lots of help. I have a recovery coach. I have a sponsor now, which I've never had a sponsor before. I have a therapist and a psychiatrist. I attend AA meetings weekly, like 4 to 5 times a week. I see my recovery coach every week. I talk to my counselor about every 2 weeks now. But I feel like I'm doing a lot better than I was during this incident. I was not in a great mental place.
Okay. Ms. Odell, did I see a recommendation for community service in here?
It's
heard it mentioned.
in the CFJ 145.
Oh,
I believe it's 480 hours.
all right, thank you. All right. All right, thank you. All right, well, the court takes a look here. Number 1, it's an intermediate sanction cell. That tells the court we're supposed to start with the presumption of no jail. However, there are some exceptions, and one of them is for a drinking and driving third. The court is required to either do a year in prison up to 5 or a combination of probation with 30 days of jail. Well, a year in prison would exceed the scoring of 0 to 11 months. While the court is not required to comply, the court must take that into consideration. And in my professional experience or judicial opinion here, prison term is not appropriate. So therefore, we're looking now at a jail term. The court also recognizes that the defendant has a relatively minimal criminal history. She's got no prior felonies of any kind. There was only 1 conviction. She wasn't on bond or probation at the time. And she's the one that helped even get the police call been involved. So, and she's done a lot here. When I look at substance use assessments and letters, sometimes I look through them and I pick them apart. Well, there really wasn't there wasn't anything for me to pick apart. Normally it's really easy because the letters always say kind of the same thing, but it might be a different kind of case. You've done a lot of the right stuff. And I appreciate that. And I appreciate it because hopefully it's what you need. Sentencing is not always about punishment. It's just as often about rehabilitation. The key question here is what do you do when you walk out of, Anyway, yeah, we'll walk out of the courtroom because I'll probably do jail by a certain time today. But anyways, on the weekends, which what you do when you leave, right? Because you right now, while you're on probation is what I'm. Right now, I generally expect people to do something. A lot of them don't. You did. I generally then expect people to do, if they're going to do something, do a lot. Well, you actually did. So I appreciate that. Now, I hope that it doesn't stop when you don't get to see me, right? So that I'm not there looming over you. But we do have probation, and probation is there to also help you. And that's what I want them to do. They're going to monitor you. You don't want to start drinking again. You don't want to get caught doing anything. Driving while your license is suspended, things like that. All right, so the order of the or sentence of the court is as follows. Again, I find this to be reasonable and proportionate based upon the contents of the mitigation report, the things I've addressed on the record, as well as contents of the PSI. 24 months of probation. The court adopts the terms or conditions for that probation that are listed on CFJ 145, pages 2 and 3. Now, I see there's been some recent opinions from the, I think from the appellate courts here, and I say I think, I mean, I know, where they talk about even marijuana. And I see here that marijuana was an issue, or she said used it, and this other thing, kratom. Well, I still think it's appropriate to limit other intoxicants, which can and does, in my mind, include recreational marijuana. If you have it as a prescription, I can't do anything about that, but I can if it's recreational. And the reasoning behind it is, number one, if it's not medicinal, then it's not needed. If it's not needed, but you're using it and mixing it with alcohol, then you're not addressing whatever might be causing the underlying substance use disorder, right? If somebody is using one substance like alcohol and they're using another one, if they get rid of alcohol, they might take more of the other one and then not address the problem. Then all you're doing is masking it, whatever it is. So at least while you're on probation, I don't want you using any of it. Hopefully that makes sense. So that's the reasoning for it behind this court and its sentence. All right, $68 state minimum fee, $130 crime victims' right fund fee, a $300 court cost for the processing of this case up until today, a $500 fine, which is the minimum amount required for the offense, a $300 attorney cost for the representation by the public defender's office, $60 DNA fee as if it's a first felony that's payable to the Missaukee County Sheriff Department. Supervision fees will be $30 a month or $60 a month if there's any electronic monitoring, although I don't anticipate there being any electronic monitoring. $100 restitution for the prosecution of the case and responses, and that's payable to the prosecutor's office. Or you want to go to the sheriff's department? Goes to the, Missaukee County Sheriff Department. Okay. As for a period of jail, the court issues the minimum required 30 days of jail with 2 days of credit. And the court will allow that to be served by the defendant on the weekend. Now, here's a bit of a challenge here for you on the weekends. The jails, just not like the jails have a process where they put people into an incoming cell. And then after a few days, they then go to the more of the general population area. But when you come and go, you don't always, I don't think you always make it into the general pop area. Am I correct? I know that's how it works over in Wexford. So, but anyways, it'll be easier for you. You can serve it. So what I'm going to do is I'm going to order for today that you must report to the Missaukee County Jail here in this building no later than 4 p.m. All right. And then, so you can serve on the weekends. That means you'll get a day credit for Friday, Saturday, Sunday, and then you get released on Monday, early in the morning. That's 4 days, but you're not really doing a full 4 days times 24 hours. Now, the only question that I have for you is, do you work It has to be at least 48 hours in a row. So tell me.
I was, after the sentencing today, that's when I was gonna start looking for employment.
Okay. So here's the point. It must be served in at least 2-day increments. It's easy for you because you get 30 days minus 2, minus 5 for good conduct time. So now you're down to 23. And you can knock it out faster if you do the way I just suggested. When I say suggested, it's not a suggestion. But anyways, I can amend it if it fits your job, but I don't know what you need. So if again, you're in by, as long as you're in there by 4 today, 1 day, Saturday, 2 days, Sunday, 3 days, Monday, get out at 6 or 7 in the morning, boom, that's 4 days. That means instead of doing it for 8 weekends, you're doing it in like 4 or 5 or 5 or 6, something like that. So if Mr. Hartel comes to me and wishes to modify that, I'm more than willing to modify it if you get a job. Okay? Yes, Mr. Hartel?
Just so the court is aware, I do believe our recovery coach has joined us, Your Honor.
All right, thank you very much. Well, I do appreciate her. I recognize the tag there. So anyways, you did a great job speaking. I don't need you to log on. I read the letters and everything else. So, all right. Anything else that I've missed, Miss Odell?
No, Your Honor, thank you.
Mr. Denon?
No,
Judge, did you state the community service?
No, I did not. Thank you very much. I knew when she started to chime in, and that was 480 hours of community service. I should need to inform you that you can be released from your probation at halftime as long as you're successful with all the terms and conditions. You also have to pay all fines and costs are due within 56 days. 56 or 52? Why am I forgetting them? 56 days. And if not paid, 20% penalty will be added. However, I will waive that 20% penalty as long as you make the payments by the end of your probation. So if you pay them all off in 12 months and you've done everything else right, you'll be off in 12 months. If you're still making payments, which is absolutely fine, at the 12 months, then you still continue until you reach 24. Hopefully that makes sense. All right, Mr. Hartel, anything else I need to know about how I'm having her served?
No, Your Honor.
All right, thank you. Any questions, ma'am?
No, I appreciate it.
Thank you very much. We are adjourned. Best of luck to you.
Good morning once again, everybody. It is TCF Live on a Super Friday, now entering hour number 3. Let's go to Georgia, Fulton County. This is Judge McAfee.
You want to go back on?
It is.
Ms. Clark's handling this, I think.
All that going and put them in a breakout. Okay.
All right. We ready to start?
Yes, Your Honor.
All right. We're on the record in indictment number 26 SC 002860. Are you Mr. Dustin Hagedorn?
Yes, sir.
All right, we can go and get started.
Thank you, Your Honor. ADA Clark for the state. Your Honor, the state for the record is amending count 1 aggravated assault in the indictment to, or reducing it to simple assault under OCGA 16-520 for the purposes of this plea.
Noted.
Please raise your right hand, sir. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Okay, you can put your hand down. Please state and spell your correct legal name.
Dustin Hagedorn, DUSTIN, space HAGEDORN.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you've not taken or been given today?
No.
How old are you?
37.
What's the highest level of education or the last grade you completed?
12th grade.
Are you read, write, and understand the English language?
Yes.
Do you understand that you've been charged with one count of simple assault, misdemeanor?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
You could just
Oh, okay.
turn to, I can
All
see
right.
you in the screen. I appreciate it, but thank you. Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Could you repeat that?
That's it. Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, understood.
Have you had an opportunity to review the indictment with your attorney?
Yes.
And did you understand the indictment as explained to you by your attorney?
Yes.
And have you had an opportunity to review your constitutional rights and the waiver of those rights for purposes of this plea with your attorney?
Yes.
And is it your decision to waive your rights for purposes of this plea today?
Yes.
Have you had enough time to speak with your attorney about the charge in the indictment against you, including the facts and circumstances relating to this charge?
Yes.
Are you satisfied with your attorney's services?
Yes.
Attorney Simonoff, do you waive a formal reading of the indictment?
Would you so waive?
Do you waive any defects in the indictment for purposes of this plea?
Would you so waive for the purpose of this plea?
Is it Defendant Hagedorn? Is that correct?
Yes.
Okay. Has your attorney advised you of the minimum and maximum sentence for the charge to which you're pleading guilty today?
Yes.
Okay. I'll put those on the record. For a misdemeanor charge of simple assault, the minimum is 1 day in jail. The max is 12 months in jail. Do you understand that you are entering a negotiated plea of guilty?
Yes, ma'am.
Which means that the state and defense jointly will recommend the following sentence to the court. The state's recommendation is 12 months. The defendant will be given credit for time served, balance on probation. The only special condition is that the defendant will have nonviolent contact with the victim, in this case, Zarania Hill. Her name is spelled Zariannah, Hill, common spelling. Is that your understanding of the terms of negotiation?
Yes.
Do you understand that the court is not required to accept the state's recommendation?
What was that? Oh, okay.
But if he doesn't, you have a chance to withdraw your plea.
Okay. All right.
Do you understand that, sir?
Understood.
Okay. So the questions that I'm asking, and hopefully this is your first time and last time ever going through this. This is just me as the prosecutor. I have to make sure that I ask you certain questions, but anything I ask you, you are free to ask the judge or confer with your attorney before answering, okay?
Okay.
All right. Do you understand that the court has the right to sentence you to the maximum possible sentence on this charge?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty as your case has just emerged on the plea and arraignment calendar?
Yes.
Are you currently on probation or parole?
No.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow the special condition of having no further violent contact with the named victim in this case, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Understood.
Are you a United States citizen?
Yes.
Attorney Simonoff, is he not seeking first offender, right? Okay. Just want to make sure. Do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision to waive these rights, which means not to use any of them, and to enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
No.
Pending your hesitation, the state will ask you questions under the North Carolina versus Alford. Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes, ma'am.
As to indictment number 26 SC 002860, how do you plead to the sole count of simple assault?
Well, I'm pleading guilty.
Okay. Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5635 and can be reviewed with your attorney. And if you decide to make that appeal, it must be done within 30 days from today's date. Do you understand?
Understood.
Do you understand that if you wish to challenge what is called the volunteerness of your guilty plea, you must do so within 12 months from today's date by filing a habeas corpus petition? Do you understand?
Yes.
Your Honor, at this time, the state and defense have agreed to stipulate to the factual basis in this case. The state has been in contact with the victim in this case. Ms. Hill has indicated that that this is a one-time situation and that she is in hopes that the defendant will get out of custody as soon as possible. She does not wish for him to have a felony on his record, that he's a truck driver and he's an honest and good person. So based on my communications with the victim in this case, the state decided that this was the more appropriate sentence recommendation.
Okay. Mr. Hagedorn, I'm going to go through a couple questions with you real quick, all right?
Okay.
Do you understand the nature of the charges against you today?
Yes, sir.
All right, and you just heard the DA explain a lot of the facts and the fact that you're giving up certain rights and entering this plea. Is that what you're here to do today?
Yes, sir.
You understand I'm not bound by the offer that you and your attorney have agreed to. I can sentence you to whatever I choose. You'd have the right to withdraw your plea at that time if I did.
Okay.
But by entering a negotiated plea, that you have some control over what the ultimate result of this case is going to be.
Okay. Understood.
All right, and you're entering an Alford plea?
Yes.
All right. So you're not admitting guilt, but have you decided that it's in your best interest to plead guilty here today? Because it's possible if you go to trial, you'd be convicted anyways.
I just think that it's a good deal, and I just want to go home and move on with my life.
All right. Are you entering this Alford plea freely and voluntarily of
Yes,
your own
sir.
choice? Okay. Mr. Simonoff, are you satisfied your client is competent in understanding that this plea is freely, voluntarily made, and he understands all the facts that are relevant to making that decision?
Yes, Your Honor.
All right. Is there anything you'd like to say at this time, Mr. Simonoff?
Yes, Judge. We are requesting credit for time served for 61 days. He's been in custody since the incident date, which was May 18th, 2026. And we have filled out the contact sheet for misdemeanor probation as well, so that'll be ready to turn into them.
All right. Well, I find that this plea is freely and voluntarily entered, that there's a full knowledge, understanding, waiver of rights. No promises, threat, or use of force have been used to induce it, and there's a factual basis for this plea. Mr. Hagedorn, I'm going to accept the negotiated plea. I'm going to sentence you to the reduced charge on count 1 of assault to 12 months. Was it simple assault or? Simple assault. Count 1 will be simple assault. Was it 12 months probation?
Yes, Judge.
To serve 61 days credit for time served. And there'll be a special condition of no violent contact with the victim, Ms. Heel. All right. Anything else, counsel?
No, Judge.
All right, Mr. Hagedorn, good luck. Hope you don't come back.
All right. Thank you.
Thank you.
Your Honor.
Alrighty, friends, let's head west. We'll go back to Texas, check back in with Judge Stevens, new contestant there.
State of Texas versus Philip Bennett. Is it Bennett or Bennett? Bennett. And you were here with Mr. Adams, your attorney, and the state's attorney.
Yes, sir.
What we have here is a motion to revoke probation. Is this the one filed on October 30 of last year?
Yes, sir.
Is that right? Yeah, that's locked. Everybody, is that right? He says yes. Was that right, Langston?
Yes, yes, sir.
And state?
Yes, you.
Okay, good.
Right here.
All right.
October 30th.
I didn't know if there was another one coming through the pike or anything.
No, sir.
All right, in 24 CR 303, the state of Texas versus Philip Lawrence Bennett. Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this motion to revoke probation hearing shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir. Sir.
Lower your hand. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary, Mr. Adams?
Yes, sir.
In summary, this motion, which was filed October 30th of 2025, in summary, it states that on August 27th, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation for the third-degree felony of deadly conduct by discharging a firearm. Is all of that true and correct, sir?
Yes, sir.
Allegation 1 states you committed the offense of driving while intoxicated, I guess operating a motor vehicle while intoxicated, a DWI,
Yes, sir.
on or about October 4th, 2025 in Jefferson County, Texas, which was a violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state. Is that allegation true or correct, sir?
Yes, sir.
Are you pleading true and correct to that voluntarily and because it is true as it is alleged?
Yes, Your Honor.
Do you understand that a voluntarily and knowingly made plea of true to one or more violations, that's enough to grant a motion to revoke probation? Your probation can now be revoked. You can be found guilty and you can be sentenced to no less than 2 nor more than 10 years confinement in prison under this third-degree felony. Knowing that, do you insist on pleading true today?
Yes, Your Honor.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Let's see, I'm looking at number 2 is failed to never become intoxicated. Do we really need that one? We've got the DWI.
State's willing to abandon that, Your Honor.
3, failing to provide verification performing community service hours.
I'd like to leave that one in, please, Your Honor.
All right, number 3 states you failed to provide verification of performing community service hours. And according to the administrative hearing filed by the probation office to support the filing of this motion, it states that you were assigned 600 community service hours. You completed 276 and have 324 remaining. Let me ask on probation. Was he doing okay on community service hours? He didn't complete them, but he was only on probation for a year.
Yeah, he was always almost at his halfway mark, Your Honor.
Okay. Well, okay, he was at his halfway mark on what?
Community service hours.
Okay, and he was on probation for 10 years, but he had only been on probation for a year, right?
That's right.
So he was about 10% of his probation time, but he had served half, he had covered half of his, that's pretty good, isn't it?
Yes, Your Honor.
Okay, I'm not gonna punish him for that. It sounds like he was trying. We're gonna be okay on that one. Can we abandon that?
Judge, if the court's inclined to find it not true, then I don't necessarily want to abandon it.
But where was he on? I mean, was he didn't complete it, but was he caught up?
He was almost caught up, yes, sir.
Well, I'm not gonna punish it.
If the court's inclined to find it not true, then that's fine, Judge.
All right. Number 4,
we'd like to keep number 4 and abandon number 5 with regard to the fees, Judge.
4 states you were at a location other than your residence at approximately, it says 23:49, that's military time. I presume that's 11:49 PM on or about October 4th, 2025, in violation of condition 18 of your probation order, and 18 of your probation order states that you must be inside your home every day between 10 PM and 6 AM except for employment purposes. So that was about 2 hours outside your curfew. Is that true?
Yes, sir.
Are you pleading true to that one violation true because it is true as it is alleged?
Yes, Your Honor.
And I've already told you that unknowingly and voluntarily made plea of true to one or more violations, that would be enough to grant a motion to revoke probation, and your probation could be revoked. Do you understand?
Yes, sir.
No. And we're abandoning 5.
Yeah, Your Honor, with regard to the fees.
Let's
State has a brief argument.
hold on, we've got a second case.
We get to argue. Huh?
We've got a second case to deal with
I
too.
think they've got the same mirror allegations, Judge.
Mm-hmm. Well, we got to pick them up.
Okay.
So 24 CR 304 is called the State of Texas versus Philip Lawrence Bennett, who is the defendant. And in this case, there's a motion to revoke probation filed as well as of October 30th of 2025. Does the defendant waive a formal reading of this motion? Can we proceed in summary?
Yes.
All right. And again, you're still under oath in this hearing, so remember that. All right. In summary, this motion to revoke unadjudicated probation states that on August 27th, 2024, 2024, in this criminal district court of Jefferson County, Texas, you were placed on 10 years deferred or unadjudicated probation, as well as in the previous case for the 304 case of deadly conduct discharging a firearm, a 3rd-degree felony. Is that true?
Yes, sir.
And
State abandons allegation number 2, Judge.
allegations 1 and 4 are the same as what you have pleaded true to in the previous case, committing the offense of driving while intoxicated on or about October 4th, 2025 in Jefferson County, Texas, and 4 at a location other than your residence at approximately 11:49 PM on or about October 4th, 2023. And those are violations of conditions 1 and 18, respectively, of your deferred or unadjudicated probation order. Are those allegations true and correct as they are alleged?
Yes, sir.
And are you pleading true and correct to those?
Yes, sir.
Voluntarily and because they are true as they are alleged?
Yes, sir.
And again, you are understanding that a true and correct violation of one or more violations of probation, that is enough to grant a motion to revoke probation. Your probation can be revoked and you can be sentenced up to the full range of punishment. In this case, it's the same as the previous case in the motion to revoke probation. You were looking at no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. Knowing all of that, do you insist on pleading true to allegations 1 and 4 in this cause number 24 CR 304 in this motion to revoke probation, as well as the previous one?
Yes, sir.
I find you are pleading true, voluntarily, knowingly, intelligently, and there is enough to grant these motions to revoke probation, enough evidence by a preponderance of the evidence or greater to support the motions to revoke probation. What are we going to do?
Judge, it's a cap of 5, and I got 2 witnesses I want to call.
And go ahead.
All right, I want to call a probation officer as the first witness. All right. All right.
Hold on and raise your right hand, sir. Do you probation? But I like your vigor in raising your right hand. You solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth. So help you God. So lower your hand and go ahead.
Will you state your full name for the record? Jesus Ruiz. And Mr. Ruiz, you were the probation officer in this case? No. Okay, who you covering for? Joseph Champ. All right, so you're covering for Mr. Champ. That's fair. That's no problem.
Hold on. Are you familiar though with these files to be able to speak intelligently about what's in them?
Somewhat familiar, yes.
All right.
So basically what Judge said, you had a chance to review all of the notes of Mr. Champ and everything that he's done in this case? Yes. All right. And in doing so and reviewing Mr. Champ's notes, you understand that my client was placed on probation on the 27th day of, well, he was placed on probation specifically. This order was entered on 10/30 of 2025. That's the date that I see this file stamp. All right. All right. And let's deal with one of the allegations that was abandoned. And I think that that's positive for my client. You understand the judge pointed out that in terms of his community service, he's placed on probation for 10 years, right?
I want to be clear, the state didn't abandon that allegation.
Yes, you did.
No, I did not abandon the allegation about the community service. I welcome the court to find it not true if he was so inclined, but I didn't abandon.
Okay, well, at the bottom line is that would you, in terms of failure to provide verification of community service office, you do know that he's done over 50% of his community service? Not 50%. How much has he done? 276 hours. Out of how many? 600. 50% will be 300 hours. Okay, so he's pretty close. Pretty close. So as it relates to providing verification, you do know that he did do the 200 and what? 76. And do you consider that doing pretty well? It's pretty well. That's pretty well. And is that better than most people who's on probation? I'm not sure. What are people who you supervise? They tend to meet the halfway mark. Okay.
And 93% are successful.
All right. The next point that I want to make to you is that in addition to doing his community service on his arrears, I noticed that these arrears is just $308. Is that right? Yes. Right. So he has been making payments while he's been on probation, is it right? Has been making some payments, that's it. Well, not just some. I mean, at least according to what I got here, total credit 1,112 is what I read right here for the total credit as payments. Yes. Right. So he's not just making some payments. He made at least 1,112. I mean, so he's making payments, right? Yes. And I see that he's periodically making $60 payments, $155, $115, $105, $85. So he's making regular payments. Yes. Right. And that only left him with arrears of 308, right? Yes. Right. And in doing these cases, I've seen people that's $1,000 in arrears, right? Yes. So as another positive about my client, he's making payments and he's also ahead of the game in his community service. That's a positive, right? I don't know about ahead of the game, but he's on his way. Yes. Okay. Also, as it relates to the nature of the offense that the state is going on for this October the 4th, you did get a chance to look at Mr. Champ's notes and administrative hearing. In terms of this DWI, this is not a DWI where we got an accident, somebody's injured, a DWI where somebody is a danger to the road. This is one where he is in a parking lot parked and the underlying, and you can look at it if you don't, just refresh your under findings. They had administrative hearing and he's basically, have you seen this? Yes. Yeah, he's basically in a parking lot parked, right? Mm-hmm. So he's not driving a car at that time, is that right? No. Right. And so in terms of the seriousness of this particular offense, this isn't a DWI where you got a wreck, somebody injured, he's on the road, he's in the parking lot sleeping. Is that right? Yes. Now, the judge has mentioned about the success rate of the probation department in terms of programs that you can provide for him that he's admitted to on the driving while intoxication on October the 4th. What programs does this probation office provide for people who have some alcohol problems? Do you have any programs? We have substance abuse assessments that we provide. We do have programs, yes, sir. And at the time of this offense, was he getting any of those substance abuse treatment? I am not sure. Okay, and if he's continued on probation by our judge today, could the judge order him to take the substance abuse treatment while keeping him on probation? That's his decision. Actually, could he do so? And the answer would be yes, he could, right? All right. Now, how do you feel about that substance abuse treatment program? Do you think it's a pretty good program? It is a pretty good program. How well is it? How would you describe it? With my clients, they've had pretty good success. All right. So do you have any reason to believe that if he's continued on supervision and he's put into this program that he would not be successful? I'm not sure. All right. But you don't know the client well enough. I got you. Make that decision. But in going through the notes of Mr. Champ, you don't see nothing that would say he wouldn't be successful, would you? No. All right. So in addition to the programs that you provide in your department, which is the substance abuse, how about in the community as a whole, Jefferson County? Do we have programs here to help people with alcohol, like AA, right? So not in addition to the programs that he would have access to through your department, which is in the community as a whole, we would also have access to those programs, right? Yes. So if the judge with this 5-year cap offer continues him on supervision, he could be in those programs and not be a danger to anybody in the community. Is that right? I don't know about that. I could be in the program and still be a danger. Well, you could be a danger to somebody today.
That's argumentative.
No, well, that's
State objects. That's argumentative.
sustained. Well, at the end of the day, anyone can be a danger at any particular time. Do you understand that? Yes. All right. So in his particular case, if he has the program that you just bragged about, if he has the access in the community and he's doing what he's supposed to do, he can probably continue to be on probation and be successful. Do you understand that? Yes. All right. And the probation department can meet all of his needs that need to be met. Is that right? Yeah. By continuing him on supervision. All right. Last question for you, and here's where I'll stop. I know you said that you were not the supervising officer, but in reviewing Mr. Champ's notes, from reading his notes, what are the positive things you can say about my client? From your reading of all of his notes. He was somewhat compliant with his probation. He was going to office visits. He was doing pretty good on this community service, and he was meeting his payments. Okay. And did Mr. Champ express any feelings to you about this particular case? So when you covered for him, you basically took the file, but you didn't talk to him about as to what Mr. Champ's recommendations were, right? No. All right. So you're not prepared to give a recommendation today. That's more for Mr. Champ. Well, he's retired. So, well, he's retired. Well, he can't now, but I'm saying he's not here to give a recommendation because he's the main one, right? Mm-hmm. And what you say that you can't do it because you're not the one who supervised. All right, pass the witness. Thank you for your time.
If I may, Your Honor, I'd like to direct your attention to the administrative hearing and the report or the document from that hearing dated October the 6th of 2025, particularly the findings. And if you need to, just take a quick look at it to refresh your memory of that or recollection. Oh, and just tell me when you're ready. All right. All right. Particularly with regard to these highlighted portions of the findings, when the officer or officers encountered the defendant with regard to the DWI arrest, where was he located?
He was in the middle of the parking lot.
At where?
At Taco Bell.
And did other vehicles have to go around him? Yes. And it was indicated that when law enforcement made contact with the defendant, what state or condition was he in?
He had thick saliva running out the side of his mouth.
And eventually, the officers, how did they get the defendant to awaken or respond?
They had to be on the driver's side of the vehicle.
Okay. That's all. I'll pass the witness.
So basically, in what you said, I mean, people don't speed in parking lots, right? I mean, you shouldn't be, you shouldn't be. All right. So in terms of what he's in the middle of a parking lot and the saliva that comes out of mouth, I mean, the common term for that is drooling. I mean, that's associated with sleeping. You understand that, right? And at the end of the day, he's parked in a parking lot sleeping, and in that parking lot in Taco Bell, people drove around so they can get into the line to order their food. All right, so for purposes of continuing him on probation and how this question is relevant for the judge and continuing him on probation, out of all the kinds of DWIs you can have, this is not the most serious one. You don't have him drunk and killing somebody, drunk and getting into a wreck, drunk and hurting himself, drunk or hurting somebody else. He's sleeping in a parking lot. Is that right? Yes. Right. So, and that would be one of the arguments and basis for continuing on probation as it relates to the seriousness of the offense. Pass the witness and
Just one follow-up question, Judge. Based on your experience, your life experience, how do you surmise that this defendant got to that parking lot there at Taco Bell?
the rejection speculation, his life experience is irrelevant to the question. It's told whatever his life experience is not a relevant question for this case. His life experience is not material to this case.
Your Honor, the court can draw an inference. I'll move on.
Go ahead.
That's all I got, Judge. I got another witness. That's it.
All right. Let me ask a question here. I'm looking at all the papers. The agreed punishment recommendation here, a cap of 5 years.
Made by the previous prosecutor, Judge.
It says the sentence will run concurrently with the DWI. What DWI are we talking about?
The underlying offense.
I think it's in Judge Holmes, if I'm not mistaken. And he's going to handle that too and try to dispose of everything.
That's the underlying offense, the Taco Bell incident we're talking about.
Okay.
I believe
so there's not an agreement that this each of these would run concurrently. Each of these motions
they can run together.
That's not what this says. It says will not exceed a cap. Look what it says.
No, I believe
it doesn't. It just says the DWI. It doesn't say concurrently with the other.
I can add that. It was.
Is that the plan?
Yeah, that was the plan.
While I didn't negotiate it, Judge, I can understand that would be the intent of the parties.
Right.
Okay.
Right.
You want me to add that?
Yes, sir.
No objection, Judge.
Okay. This is 303. So what I'll do is we'll run concurrently with DWI and 24 CR 304. Good. Okay, what we'll do on the other plea agreement, it will run concurrent. The 304 case will run concurrently with 303 on the other one. We'll make a change on the other one as well. Langston, okay?
Yes, sir.
Go ahead. Y'all go.
Edward Bolt line. This is Van Love.
Come on.
It's finished. I don't have any more questions for you.
No, she's going to come up. He's going to have to see the bailiff. No, the bailiff makes the decision when they're in custody. He can sit right there though. He'll be present, or he can sit in the witness chair. I don't care.
I don't even point. That's something new. I mean,
we don't do that. It's up to the bailiff's decision. I mean,
I don't know how that affects any substantive right of the judge.
It doesn't. Okay. He's present. Yes. He's present. That's what's important. He's present. They don't have to stand next to each other for the law to apply. Go ahead. Call your witness. What's your name?
Can you state your full name for the record?
All right. Raise your right hand, man. Do you solemnly swear or affirm the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Correct? Okay. Lower your hand. Thank you. Go ahead.
All right. Mr. Bennett, my client, how do you know him? All right. And were you with him when he got first put on probation? Were you helping him?
Yes.
All right. And do you understand that today is a motion to revoke his probation and the judge could put him in prison up to 5 years and keep him on probation? Do you understand that? And as his grandmother, you're here today to talk about how well he was doing while he was on probation, right? Could you tell us some of the good stuff that he was doing while he was on probation?
I can't.
Well, speak up, she can hear you.
Whenever I needed him to help me around the house, he was always there present. And he helped me pretty well. And he always was obedient for me.
Yes, ma'am. So how did he help you? Do you depend on him?
Well, yeah, I really depend on him. Like when I needed lights changed on the flood lights.
Mm-hmm.
He was there. He kept me warm.
So basically, the heart of why you're here is you're here to testify to why would you want the court to continue him on supervision, right? And not send him to prison. So can you tell the judge in your own words, why would you ask the judge to keep him on probation?
Because we have a really bad at all. It's so deep. We have a kind of heart. And we like to work.
And if he's on probation,
Take care of the son. His 3-year-old son.
Now you heard the probation officer talk about what kind of great substance abuse program that they have. If judge keeps him on probation, would you help him with transportation and getting the substance abuse treatment that the probation officer just talked about?
I don't drive no more, but I can get someone to bring.
You better get somebody to bring him. And who's the lady in the blue?
That's his mom.
That's his mother. So his mother has transportation, right? And the mother's who got you to court today, right? And do you know whether or not she'll be willing to get him transported to where he needs to go on probation? Yes. And apparently he's been doing pretty good because he's been paying his fees. He's been reporting, at least from what they're saying. He's doing well with his community service, right? So all of those are positives and would be indicators that if he is continued on supervision, he's going to do well. So no need, right? Right. And another argument, and I'm asking you, it's a question, would you agree with me? Did you hear the court, mention with the other lady about, having the taxpayers' money and spending taxpayers' dollars? Wouldn't it be better to continue him on probation with the support of his family and the support that he has around him than to have our tax dollars locking him up in prison where he's not going to get that support, right? Okay. And he's not, and in your opinion, do you believe that he's going to be a danger to himself or anybody else, or he's not going to be a danger? And even in this underlying case, he was in the car basically sleeping, right? Mm-hmm. And with those other resources, AA and all the other resources that Jefferson County has, would you and the mom make sure that he gets that treatment and those things? Yes. All right. So at the end of the day, and here's where I stop. Do you want your grandson to be continued on supervision? To continue to be on probation, that's what I mean. Yes. That's all I got. Thank you for your time.
I have no questions for this witness, Judge.
All right, anything else?
I think
Anything
that's it. Unless you want to give
from anybody?
anybody.
Okay,
Huh?
all right. She can be seated and the defendant needs to come up.
Well,
Are you calling somebody else?
That'd be 30 seconds. Come on, man.
I'm just waiting.
And I'm just gonna ask her one question. What would she like to tell you? And that's it. And that's his mom. I'm just gonna ask one question, and you can tell the judge whatever you like.
Well, Judge, I would have kind of objected to the narrative.
Hold on. Identify her.
All right, would you state your name?
Yes, my name is Stephanie Bennett.
And how are you related?
I'm Miss Moan.
Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Yeah, it depends on where it was. Let him ask if you want to make an objection.
Well, Judge, in response to him, a narrative of response is not necessarily objection.
You just ask the question and we'll play from there.
All right. What did you want to tell the court?
Yes, sir. I'd like to let you know that I do have a job. You know, make a lot of
I'm talking about him.
plenty of money. Yes, sir.
Yeah,
And
how's that relate to him?
Yes, sir. And it's my son. And I have a little money I give to him. He wanted to be a man, so he cut grass to pay his fees. So when he was paying $80, he wasn't just sitting in the house. It was very hard for him to get a job as a felon.
Yeah.
So he did cut grass. He did what he could to pay. And when he started his job, he had to do training. So he got to bill back and they did on his community service, trying to work and provide for his son. He has a son with special needs right now. Just found out.
I'm sorry, what?
Special needs.
He has a son with the special needs. He's autistic. And
Well, wait. Where does that son live?
that son lives with me and his mother. While the mother worked, we have the baby.
No. Okay. When he wasn't in jail, where was he?
He was with
and the child.
He was taking care of his son while the mother worked. And between
Really?
his work, yes, sir.
Okay.
And he also took
Hold on.
care of my mother.
Hold on. Well, let me ask you, not to interrupt you, but who's taking care of that child at midnight when he's drunk and intoxicated and inebriated at a location and completely
His son.
unconscious, who's supposed to be taking care of this child that we're so concerned about, that he's supposed to be loving and caring for, like me as a parent, because I've got two children.
The mother. He had just got.
Well, where's the mother?
The mother, she's.
At the
work.
time.
They don't live.
She was at work. Wait a second. He's intoxicated and wiped out
Right.
at the drive-through, and the mother is working. What's the child doing by itself?
No, the mother wasn't working. He had gotten off.
You
from
said
work.
she
The
was
mother
working.
had the baby. The mother was at home. He had gotten off from work. He was at work that night. And he had gotten.
Why wasn't he at home taking, it takes, I'm a parent. It takes two to run the household. Why isn't he at home at midnight when
Because-
he's supposed to be just as a good parent? But not only that, he's ordered to be at home. What is it, at 8 p.m.? He's ordered to be. He was 4 hours late. He's intoxicated and unconscious in the public while the family is at home. That's not good parenting, is it?
They don't live together, sir. He lives with me.
Okay, all right. Why is he somewhere else other than at his home where he's supposed to be as the court ordered? I know you can't. It's not fair for you. I understand.
He takes good care of my mother. He takes her to the doctor.
He can't do it when he's intoxicated and unconscious at midnight out in the public, can he? No. You got responsibilities, sir. My God. Those are special. Our Creator gives us our children, and you're supposed to take care of the gifts that are being given to you, and you're unconscious on my watch on probation when you know better. Reminding you, you're on probation not for just something, not from just spitting on the sidewalk. You shot at a car, and shot at buildings. I mean, all kinds of trouble was happening there. Many could have died. So